Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agenda's a disguise. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Listen, we are here because Sean Combs, aka Puff Daddy, aka P. Diddy, aka Diddy, aka PD, aka Love, has officially been indicted. It was the sealed indictment. There was an order of the unsealing of the indictment that came on the Pacer account. And so it looks like it's a wrap for Diddy right now. Okay. I was actually trying to watch outside of the courthouse because you know that there are a lot of people who have been covering this. So obviously a lot of the media is out there. And so looks like it's going down. That's what it looks like. So he was supposed to appear in court this morning. Again, there was an order to unseal the indictment, so it was sealed. Looks like perhaps, let me see when. Let me see. I'm not going to be able to pull it up. So this may have happened. I believe it was like the 12th, maybe, when the grand jury may have brought it down, but it was just unsealed on today. You said they're having a press conference at 11:30. Okay. Tracy said, I was thinking about going down there, but I was never going to make it back to work. Yeah, it looks like it's crowded out there, and I see a lot of people are already talking about it. I told you guys yesterday I was feeling like trash. So when I got off the live yesterday, I went to bed and I woke up at like 1 in the morning and I had all these text messages. They got him. He was arrested. I was like, man, all I did was like, see, this is what happened when you go to bed early. But it was enough people covering it last night that I think you guys were definitely fine. You didn't get jury duty? Said, I'm here, jury duty avoided. Okay. Yeah, if you guys saw my post, it's going to be very interesting to see how this goes down because I'm pretty certain that Dennis just texted me and said that it's going to be a press conference soon. Yeah, I actually do have the Associated Press on because I'm sure they've been out there since early this morning. So that's who I was watching while I was trying to watch this good docket. So you said you're entitled to get some rest. I appreciate that. But yeah, I missed out on all the news. I'm like, man, we've been waiting on this for a minute and I missed out on it. So yeah, I'm up here now trying to make up for everything I was supposed to do yesterday work-wise. But anyway, we have the indictment, y'all. Let's go through it. Let's see what's going on as you guys come in. Make sure you hit that like button. You girls out here working early in the morning. It has the overview is count one is racketeering conspiracy. The grand jury charges for decades Sean Combs, aka Puff Daddy, aka P. Diddy, aka Diddy, aka PD, aka Love. The defendant abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influences of the multi-faceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other things, trafficking, forced labor, kidnapping, arson, bribery, obstruction of justice. Wow. Wow. Sean Combs, aka Puff Daddy, aka P. Diddy, aka Diddy, aka PD, aka Love. The defendant operated his business headquartered at various times in Manhattan and Los Angeles under a variety of United States based corporate entities, including Bad Boys Entertainment, Combs Enterprise, and Combs Global, collectively the Combs business. Corporate entities in the Combs business included, among other things, record labels, a recording studio, an apparel line, an alcoholic spirits business, a marketing agency, and a television network and media company. At all times relevant to this indictment, Sean Combs, aka Puff Daddy, P. Diddy, PD, and Love, the defendant, engaged in a persistent and pervasive pattern of abuse towards women and other individuals. This abuse was at times verbal, emotional, physical, and sexual. As part of his pattern of abuse, Combs manipulated women to participate in highly orchestrated performances of sexual activity with male commercial ex workers. At times, Combs and others acting in his direction made arrangements for women and commercial ex workers to fly to Combs' location. Combs ensured participation from the women by, among other things, obtaining and distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same, and using intimidation and violence. Physical abuse of Sean Combs, aka Puff Daddy, P. Diddy, Love. The defendant was recurrent and widely known on numerous occasions from at least in or around 09 and continuing for years. Combs assaulted women by, among other things, striking, punching, dragging, throwing objects at, and kicking them. These assaults were at times witnessed by others and included one instance in Los Angeles hotel in or about March 2016, which was captured on video and later publicly reported, where Combs kicked, dragged, and threw a vase at a woman as she was attempting to leave. When a member of the hotel security staff intervened, Combs attempted to bribe the staff member to ensure silence. Combs' violence was also not limited to these women. It extended to his employees, witnesses to his abuse, and others. Sean Combs, aka all of these names. The defendant used the Combs businesses, including certain employees, to carry out, facilitate, and cover up his abuse and commercial sex. Those employees, including security staff, household staff, personal assistants, and high-ranking supervisors and other close associates, acted as Combs intermediaries, and their conduct was facilitated and assisted by Combs' control of the Combs businesses. Combs Enterprise. From at least in or about 08 through in or about the date of the filing of this indictment, Sean Combs, aka all those names, the defendant and others known and unknown, were members and associates of a criminal organization. Ooh, it's about to be some other people. Members and associates of the Combs Enterprise engaged in, attempted to engage in, among other activities, trafficking, forced labor, interstate transportation for purposes of prostitution, coercion, and enticement to engage in prostitution, narcotics, offenses, kidnapping, arson, bribery, and obstruction of justice. The Combs Enterprise, including its leadership, its members, and its associates, constituted an enterprise as defined under Title 18 USC Section 1961, Sub 4. That is a group of individuals associated. In fact, although not a legal entity, the Combs Enterprise consisted of Sean Combs. Then it has all of his AKAs. Entities within the Combs business included but not limited to Bad Boy Entertainment, Combs Enterprise, Combs Global, individuals employed by and associated with the Combs business, and others known and unknown. It's about to be some other people up in here. The Combs Enterprise constituted an ongoing organization whose members function as a continuing unit for a common purpose of achieving the objectives of the Combs Enterprise. The Combs Enterprise was engaged in and its activities affected interstate and foreign commerce. The Combs Enterprise operated in the Southern District of New York and elsewhere. Southern District is a busy district. At all times relevant to this indictment, Sean Combs, aka Puff Daddy, P. Diddy Love, PD. The defendant was the leader of the Combs Enterprise. Sean Combs, aka Puff Daddy, P. Diddy, PD Love. The defendant and others known and unknown participated in unlawful and other activities related to the conduct of the Combs Enterprise affairs. These individuals included certain Combs business employees, such as members of Combs security staff. Household staff, personal assistants, high-ranking supervisors, as well as other close associates of Combs. So all of these security that's coming out like it wasn't me, I was trying to stop them. Ooh. This is getting deep. Purposes of the Combs Enterprise. The purpose of the Combs Enterprises included the following: operating a global business in the media, entertainment, and lifestyle industries, including, among other things, record labels, recording studios, apparel line, alcoholic spirit business, a marketing agency, and a television network and media company. Preserving, protecting, promoting, and enhancing the power, reputation, and brand. The defendant as a musician, entrepreneur, and figure in the entertainment industry, enriching members and associates of the enterprise, including its leader, Combs, and in particular those who demonstrated loyalty to Combs and willingness to conceal his crimes. Preserving, protecting, promoting, and enhancing the power of the Combs Enterprise, including the power of its leader, Combs, through violence, use of firearms, threats of violence, coercion, and verbal, emotional, physical, and sexual abuse. Fulfilling the personal desires of Combs, particularly those related to Combs' sexual gratification, including through the exploitation of women and the use of commercial sex workers. Enabling Combs and other members and associates of the Combs Enterprise to engage in unlawful acts of violence, including sexual violence, sex trafficking, forced labor, interstate transportation for purposes of prostitution, coercion, and enticement to engage in prostitution. Y'all put the P on there. Narcotics, distribution, and other crimes, and concealing the commission of such acts. Securing absolute loyalty for members of the Combs Enterprise, including through acts of violence and threats, and protecting the Combs Enterprise and its members and associates, including Combs, from detection and prosecution by law enforcement authorities through acts of intimidation, manipulation, bribery, and threats of retaliation against individuals who witnessed the crimes committed by members and associates of the enterprise. Goodness. The means and method of the enterprise. Among the means and methods by which Sean Combs, with all of these AKAs, the defendant and other members and associates of the Combs Enterprise conducted and participated in the conduct of the affairs of the Combs Enterprise, including the following. Sub A, Combs and other members and associates of the Combs Enterprise wielded the power and prestige of Combs' role at the Combs business to intimidate, threaten, and lure female victims into Combs' orbit, often under the pretense of romantic relationship. Combs then used force, threats of force, and coercion to cause victims to engage in extended X acts with male commercial workers with Combs, referred to as, among other things, freak-offs. Freak-offs were elaborated and produced X performance that Combs arranged, directed, masturbated during, and often electronically recorded. And arranging these freak-offs, Combs, with the assistance of members and associates of the Combs Enterprise, transported and caused to be transported commercial X workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasted multiple days, and often involved multiple commercial X workers. During freak-offs, Combs distributed a variety of controlled substance to victims, in part to keep the victims obedient and compliant. Sometimes, unbeknownst to the victims, Combs kept videos he filmed of victims engaging acts with commercial workers. At the freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. Wow, this is a lot. Members and associates of the Combs enterprise, including high-ranking supervisors, security staff, household staff, personal assistants, and other Combs business employees, facilitated these freak-offs by, among other things, booking hotel rooms for the freak-offs, stocking the hotel rooms in advance with the required freak-off supplies, including controlled substances, baby oil, lubricant, extra linens, and lightning, cleaning the hotel rooms after the freak-offs to try to mitigate room damage, arranging for travel for victims, commercial workers, and Combs to and from freak-offs, resupplying Combs with requested supplies, delivering large sums of cash to Combs to pay the commercial workers, and scheduling the delivery of IV fluids. In or about March 2024, during searches of Combs' residence in Miami, Florida, and Los Angeles, California, law enforcement seized various freak-off supplies, including narcotics and more than 1,000 bottles of baby oil and lubricants. That's a lot. Combs subjected victims to physical, emotional, and verbal abuse to cause the victims to engage in freak-offs. Combs maintained control over his victims through, among other things, physical violence, promises of career opportunities, granting and threatening to withhold financial support, and by other coercive means, including tracking their whereabouts, dictating the victim's appearance, monitoring their medical records, controlling their housing, and supplying them with controlled substances. During and separate from freak-offs, Combs, among other things, hit, kicked, threw objects at, and dragged victims and at times by their hair. These assaults often resulted in injuries that took days or weeks to heal. Combs also threatened victims' careers and livelihoods, including if they resisted participating in freak-offs. Victims believed they could not refuse Combs' demands without risking their financial or job security or without repercussions in the form of physical or emotional abuse. Combs also used the sensitive, embarrassing, and incriminating recordings that he made during freak-offs as collateral to ensure the continued obedience and silence of the victims. Members and associates of the Combs enterprise, including Combs security personnel, at times carried firearms. On more than one occasion, Combs himself carried or brandished firearms to intimidate and threaten others, including victims of and witnesses to his abuse. In or about March of 2024, during searches of Combs' residence in Miami, Florida, and Los Angeles, law enforcement seized firearms and ammunition, including 3 AR-15s and with the face serial numbers, as well as drum magazines. Members and associates of the Combs enterprise enabled Combs' control over victims by following his directions regarding financial payments to victims, advancing or suppressing the victims' career opportunities, and acquiring the controlled substances Combs used to keep the victims compliant. Members and associates of the Combs enterprise at times witnessed Combs' violence towards the victims or the victims' injuries caused by Combs without intervening. Instead, members and associates of the Combs enterprise helped conceal the violence and abuse by, among other things, assisting Combs in monitoring and preventing victims from leaving locations such as hotels or Combs residence. These occasions included instances in which victims were required to remain in hiding, sometimes for several days at a time, to recover from injuries Combs inflicted without being publicly observed. Members and associates of the Combs enterprise also assisted Combs in locating and contacting victims who attempted to flee his abuse. So some of these people that's coming out here now talking about, I tried to leave, I was trying my best. These security and all these people that's coming out trying to make it seem like they were victims too, you guys are going to have to answer to this. That's what it sounds like to me, because they're saying this is an enterprise. This is all coming together now while some of these people are coming out doing all these interviews trying to tell everything now. And then some of these lawsuits where everybody's trying to tell everything now that don't have anything to do with the counts or the statute of limitation has expired. And they're coming out with some of this information, probably because they got a summon from the feds to come talk. And it was looking like you knew about it, you concealed it, you didn't intervene and all of that. And everybody's trying to be like, wasn't me. I ain't had nothing to do with it. That's what it sounded like to me. Hold on one second. Let's go on. When employees witnesses to his abuse or other threaten Combs' authority or reputation, Combs and members and associates of the enterprise engage in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence included kidnapping and arson. In addition, on multiple occasions, Combs threw both objects and people, as well as hit, dragged, choked, and shoved others. When Combs' authority or reputation was threatened by the possibility of negative publicity or legal or law enforcement actions against him, including in or about late 2023, following public allegations of Combs' crimes, Combs and members and associates of the enterprise pressured witnesses and victims, including through attempted bribery, to stay silent and not report what they experienced or knew to law enforcement. Ooh. On phone calls, Combs and other members and associates of the enterprise, among other things, provided these victims and witnesses with a false narrative of events in an effort to conceal Combs' crimes. Combs caused these calls to be recorded on at least 2 occasions. So it sounds like what's being alleged is that he would call people and say, remember back in 1999, man, we was drinking that day. We was all high. You know, we was all high, but nothing really happened, right? Like nothing happened with the girl, and not trying to basically prompt a narrative just in case they got summoned by the police. That's what it sounded like to me. The racketeering conspiracy. From at least in or about 2008 through on or about the date of the filing of this indictment in the Southern District of New York and elsewhere, Sean Combs, the defendant, and others known and unknown, being persons employed by and associated with the Combs enterprise described in paragraphs 6 through 12 of this indictment, and enterprise engaged in and the activities of which affected interstate and foreign commerce, knowingly combined, conspired, confederated, and agreed together and with each other to violate the racketeering laws of the United States, to wit, Title 18 U.S.C. 1962, that is to conduct and participate directly and indirectly in the conduct of the affairs of the Combs enterprise through a pattern of racketeering activity as the terms defined in Title 18. Multiple acts involving kidnapping, chargeable under the following provisions of state law: California Penal Code Section 207, kidnapping; California Penal Code 664, attempts; Section 31, aiding and abetting; and Section 182, conspiracy. Multiple acts involving arson, chargeable under the following provisions of state law. Then it has all of the California penal codes, which is similar to what I just read. Sub C, multiple acts involving bribery, chargeable under the following provision of the state law: bribery of a witness; attempts; aiding and abetting. These are all under the California penal codes; and conspiracy. Sub D, multiple acts indictable under Title 18 U.S.C. Section 1512 relating to tampering with the witness, victim, or an informant. Multiple acts indictable under Title 18 U.S.C. 1589 related to forced labor. Multiple acts indictable under Title 18 related to X trafficking. Multiple act indictable under Title 18, Section 2421, 2422 relating to transportation and inducement to travel for purposes of prostitution, put the P on, and other illegal sexual acts. And multiple offenses involving the possession with intent to distribute or distribution of narcotics and controlled substances, including cocaine, oxycodone, alprazolam, 3,4 Y'all see that big word right there? We just say meth. 4 bromo, gam. Okay, Y'all see all these words right here. These are the actual words of these narcotics. Complete words, not just abbreviation. And 846, distribution and possession with intent to distribute, and conspiracy to do the same, aiding and abetting and willfully causing. It was part of the conspiracy that Sean Combs, the defendant, agreed that a conspirator would commit at least 2 acts of racketeering activity in the conduct of the affairs of the Combs enterprise. That's it. Notice a special sentencing factor from at least in or about 2009 up and including in or about 2018 in the Southern District of New York and elsewhere as part of this agreement to conduct and participate in the conduct of the affairs of the Combs enterprise through a pattern of racketeering activity. Sean Combs, aka Puff Daddy, P. Diddy, PD and Love, the defendant, agreed to and in affecting interstate and foreign commerce, knowingly recruit, entice, harbor, transport, provide, obtain, advertise, maintain, patronize, and solicit by any means a person knowing and in reckless disregard of the fact that means of force, threats of force, fraud, and coercion as described in Title 18 U.S.C. 1591 E2. Any combination of such means would be used to cause the person to engage in a commercial X act in violation of Title 18 U.S.C. Section 1591 sub A B1. Count 2. X trafficking by force, fraud, or coercion. Victim 1. The grand jury further charges from at least in or about 2009 up and including in or about 2018 in the Southern District of New York and elsewhere. The defendant in and affecting interstate and foreign commerce knowingly recruited, enticed, harbored, transported, provided, obtained, advertised, maintained, patronized, and solicited by any means a person knowing and in reckless disregard of the fact that means of force, threats of force, fraud, and coercion as described in Title 18 United States USC 1591 sub E sub 2, and any combination of such means would be used to cause the person to engage in commercial X acts and attempted, aided, and abetted and willfully caused the same, to wit, Combs recruited, enticed, harbored, transported, and maintained a person, and attempted, aided, and abetted and willfully caused victim 1 to engage in commercial X acts knowing and reckless disregard of the fact that victim 1 was engaged in commercial X acts as a result of force, fraud, and coercion. So whoever was reporting that a lot of this stuff was based off of Cassie's lawsuit, this is sounding very similar to me. So that is definitely what it looks like to me. But again, all of these are allegations, okay? These are all allegations. He is innocent until proven guilty beyond a reasonable doubt. But all of this is looking eerily similar to Cassie's lawsuit. So I find it interesting that after her lawsuit, everyone comes out and they're kind of like Cassie gave them the courage to do so. However, a lot of this stuff looks like some people will be deemed that they were somewhat responsible, especially if you were in certain positions within the enterprise where you helped conceal, you helped transport, you bought drugs, you got a hotel room, you bought part of this 1,000 bottles of lube, or any of this stuff or whatever, that you may be held culpable as well. That is what an enterprise is you don't necessarily got to know everybody that's involved. If it's any part of the enterprise, you will be deemed a part of it. Y'all don't have to know each other. Left hand don't have to know what the right hand is doing. However, if it all comes together with one common purpose, you can be caught up in the game. I think everybody should lawyer up. Honestly, all this talking on YouTube was just, yeah. Count 3 is transportation to engage in prostitution from at least in or about 2009 up and including in or about 2024 in the Southern District of New York and elsewhere. The defendant knowingly transported an individual in interstate and foreign commerce with intent that the individual engage in prostitution and attempted, aided, and abetted, and willfully caused the same, to wit, Combs transported, aided, and abetted, and willfully caused the transportation of female victims and commercial ex workers in interstate and foreign commerce on multiple occasions with the intent that they engage in prostitution. So they're saying from 2000, at least 2009. So about the last 15 years, this is what the allegation is. Forfeiture allegation as a result of committing the offense alleged in count 1 of the indictment. The defendant shall forfeit to the United States pursuant to Title 18 U.S.C. Section 1963 in any and all interest the defendant acquired or maintained in violation of Title 18 United States Code Section 1962, any and all interest in securities of claims against and property or contractual rights of any kind affording a source of influence over the enterprise named and described herein, which the defendant established, operated, controlled, conducted, and participated in the conduct of the violation of Title 18 U.S.C. Section 1962, and any and all property constituting and derived from proceeds obtained directly and indirectly, said offense, including but not limited to sums of money in United States currency representing the amount of proceeds traceable to the commission of said offense. They want all your stuff, Diddy. Anything that, any money that you have made as a result of these allegations, they want the money. As a result of committing the offense alleged in count 2 of this indictment, the defendant shall forfeit to the United States any and all property, real and personal, involved in, used, or intended to be used to commit or to facilitate the commission of said offense, and any and all property traceable to such property, and any and all property, real and personal, constituting or derived from proceeds obtained directly or indirectly as a result of said offense, including but not limited to a sum of money in United States currency representing the amount of property involved in said offense and proceeds traceable to the commission of said offense. As a result of committing the offense alleged in count 3 of the indictment, Sean Combs, aka all these people, depending on what generation you're in, the defendant shall forfeit to the United States pursuant to Title 18 U.S.C. 2428 any and all property, real and personal, constituting or derived from proceeds obtained directly or indirectly as a result of said offense, and any and all property, real or personal, that was used or intended to be used to commit or facilitate the commission of said offense, and Title 18 USC Section 981 sub A sub 1 sub C and Title 28 USC Section 2461 any and all property, real and personal, that constitutes or derived from proceeds traceable to the commission of said offense, including but not limited to a sum of money in U.S. currency representing the amount of proceeds traceable to the commission of said offense. Oh my gosh. Let's see. Okay, yeah, they blocked out who the foreperson was. That's what I was waiting on. Substitute assets provision. If any of the above described forfeitable property as a result of any act or omission of the defendant cannot be located upon the exercise of due diligence, has been transferred or sold, or deposited with the third person, has been placed beyond the jurisdiction of the court, has been substantially diminished in value, or has been commingled with other property which cannot be subdivided without difficulty, is the intent of the United States pursuant to Title 18 USC 1963M and 853P and 22461 sub C to seek forfeiture of any other property of the defendant up to the value of the above forfeitable property. So if you transfer property to other people, we're going to get that too. If you decide to place it outside the jurisdiction of this court, we're going to take that too. If you decided to commingle, meaning I'm going to put so-and-so's name on this property so it'll look like it's not just my property, if we can trace that you still accumulated this because of these alleged acts, we're going to take that too. So there's supposed to be a press conference. I am, let's see. Is anybody watching to see if that has taken? Let me see. Trying to make sure. Let's see. Hold up. I'm going to. Where's the Associated Press at? Wait a minute. I was just watching them. Okay, let me see. We about to see. I just want to see what they're gonna say. This I do want to see. Didn't they say 11 o'clock? We're gonna have to watch this together. I gotta make a few phone calls and move a few meetings around because we got to talk about this. Thank you, Sabrina, for the Cash App, and Demetria. Thank you for the Cash App. Okay, only his attorney spoke. I sent it on IG. Okay. So what they standing out here waiting on if he already talked about? Oh, maybe they're waiting on maybe they're waiting on his oh, this is when he's supposed to arrive after. Any moment Sean Combs arrive at any federal. Let me see. Let me pull this up, Tracy. Jazzy, thank you so much. You said, girl, that's exactly what it sounds like. Enterprise roundup. I'm sure some of his security and workers were offered immunity for the Diddy dirt. I agree. And you know what? I was just talking to Really B this morning. And when we were having that conversation, I said, people really get mad at me like I am victim shaming or something, but I'm not victim shaming. I am not. I don't automatically just believe one side or another. My mind is not wired that way. I know some people are bad people. I know some people deserve to be in prison. But I also know some people get the wrong end of the stick. I know that people lie. I've seen people just blatantly lie on the stand. I'm a person that is well-rounded, that have seen both sides. That's why I can commentate on both sides. So that's why I can do that. And when I started seeing these lawsuits, you'll notice at first the Cassie lawsuit, and it was one after that. I think I went on ahead and I hurried up and I reported on it. But then subsequently, when I seen like Little Rod, I was like, even the Don Richards, Rashard, however you pronounce her last name, all of them to me just sounded like people were trying to get ahead of something, is what it looked like to me. Because a lot of the lawsuit had nothing to do with the counts. When you file a lawsuit, you can get to the point almost within 3-4 pages. If you just trying to sue somebody and say, we had a contract, you breached it, these are the terms. That's what that lawsuit sounded to me with Don. But then you get all of this stuff about how I was threatened, how I was coerced, how I witnessed this, how I did that, and how I did this. And I was just scared. And I called my daddy, and my daddy was scared. That's what really, was like, huh? So your dad was scared. Everybody was scared. So it's almost like people are cloaking themselves like, I'm a victim of Diddy. I'm not an enabler of Diddy, or I'm not a co-conspirator of Diddy. That's what it started looking like me. I am not negating that people witness things like this. But just like with the Don situation, that's why I showed the video of, if you were subjected to all of this stuff. And I'm not saying you were not, because baby, when he told them to walk for that cheesecake, I'm gonna still talk about that. I told you guys, ain't no way. Like, I knew Diddy what was like horrible, in my opinion, from that point, because it was cruel and it was mean. Then when he fired Aubrey and the other chick from Danity Kane, in my opinion, the way he did it was so cruel and was so mean that I was like, you knew back then how Diddy was rolling, and that he knew he had a sense of power, that where people were willing to compromise themselves, their dignity, their integrity, everything, just to be a part of Diddy's team and his camp. And I think that he capitalized off of that, and he's not the only one. I told you guys on my post, there's going to be several people that are also going to get pulled into this. There's going to be several people, and I also believe this is learned behavior. I don't believe Diddy just got in this game and just decided to do half the stuff he did. I believe there are other people that are bigger, that probably don't look like us, that also did things or whatever that he saw, which empowered him to do what he did. That's just my opinion. I have no proof one way or another, but I just want you guys to mark what I just said. I believe that there are more people as to why he felt like he can do, like he was able to do this. But back to Don, I had an issue because I'm like, if you saw how you were mistreated and you didn't get paid for what you did, why in the whole would you try to recruit and help other people to be subjected to this same bullshit? You know what I'm saying? I get it. They say stay out of people's business and all of that. No, when it comes to mankind and human well-being, no, you need to come. Sometimes you got to be, no, I'm not doing that. I'm not subjecting people to what you subjected me to. So people got mad at I'm not saying these people experience wasn't their experience. All I am saying is that I think a lot of people turned a blind eye, or they somehow talk to themselves into believing I'm a victim, and so nothing can happen to me, and it was all about me. I think that happened with a lot of people. So now you got, it's not just I know Gene has been out talking about this case. There's been a couple of other security. Remember Roger Bond, his name was in Cassie's lawsuit. He started coming out. Now all of a sudden he's like this advocate for domestic violence. And he was like, Cassie told you in the lawsuit, I tried to intervene. I tried to help. You see what I'm saying? Like, it just seemed a little bit ironic for all these people to come out, and then they're like, it wasn't me. It wasn't me. I tried my best. You can't sit there as security, like Don mentioning some security, I guess, that threw her in a vehicle. How do you not take responsibility as the security? Like, you ain't got nothing to do with it. You was just following his orders. Well, if you know it's committing a crime, allegedly, you shouldn't have been following his orders. That's all I'm saying. She's got a fast car. Said, yep, if I was getting mishandled and didn't or couldn't leave, I definitely wouldn't invite anyone else in unless they felt that if they brought someone else in, it would make deflect off of them. Yeah, I wouldn't. I mean, and I'm not saying everybody is me, but I know that some intellects can attest that we've all walked away from situations that were not suiting for us. We probably took a lot till we couldn't take it anymore, and we all walked away. With some of these people, you got mistreated, you walked away for 2 minutes, then you came back to be mistreated some more. And to watch some of this foolishness, I can't psychologically, it does not connect for me. And again, I know there are experts that can basically explain how the mindset is or whatnot, but I don't. I don't get it. I've walked away from major money, because I wasn't going to compromise my integrity. So it's just a little hard for me. You know, sometimes you got to take the long route when you decide to walk away, but High Vibe said, absolutely, we've definitely walked away from danger. We all have, you know what I'm saying? So I don't negate that. I don't negate, and that's, to me, that's just logical reasoning. It's not that I'm sitting here trying to bash anyone, because I am not. That is not what I believe. If you do something and you need to go to jail, and I believe there's some people in jail that shouldn't be there. I'm well balanced when it comes to it. And I think that's how prosecutors could be. You need to seek justice, not wins. So that's just my stance, and I automatically think that way. I don't think I gotta convict, I gotta convict, I gotta convict. So I think I'm well balanced when it comes to that, where I look at this stuff. But I looked at all the stuff. I started looking at them side eye, like, huh? Like some of these complaints and stuff, and it was everybody attributed to Cassie being so brave. That's pretty much what everybody attributed it to. Like, oh, well, Cassie was brave, so I came out after her. Now everybody and their mama watched Cassie get beat up and didn't say nothing or didn't do anything. Let's see here. Trace. Let me see what Tracy sent from CNN. Thank you again, Tracy, for sending that. I appreciate it. You know, I told you, I said, dang, I went to sleep and Diddy then got arrested. That's crazy. Let's see. I'm gonna put this up right quick. Thank you so much. Yes, you guys hit this like button for me. Let me see. Let's see what the attorney had to say. Thank you again, Tracy, for sending this to me. I appreciate it.
This is the lawyer. Let's listen.
I speak from all. We knew this was coming. I mean, he moved to New York, as I think some of you guys know. We brought him to New York about 2 weeks ago because we knew this day was going to come, and it's here.
Did you expect it to happen last night? Was that planned?
No, it's not planned. Certainly, it's not planned by us. I mean, he came here to surrender at a time agreeable to the U.S. Attorney's Office, and then they arrested him last night. I spent the evening with him. I was with him till about 1 o'clock. His spirits are good. He's confident.
Now, that's what was interesting to me. Typically, they do allow you to turn yourself in. If you guys follow me, when the Bishop Whitehead situation, they allowed them, they call your attorney, and courtesy, they'll let you turn yourself in. I've represented someone in a federal who was indicted, and the same thing, they gave the courtesy to let her turn herself in. I mean, they usually do that. So this attorney is saying that he moved to New York because he knew this was coming down, and he basically was, his attorney, I guess, was supposed to be in contact with the feds so that he can turn himself in. And for whatever reasons that we don't really know, the feds was like, yeah, no, we're not going to wait for him to turn himself in. We're just going to come and arrest him. So there must be something. I suspect they may be trying to remand him into custody. If they didn't just let him turn himself in like that, then it's something that's going on where they decided that it was best for them to arrest him. So I would not be shocked if they asked to remand him into custody when this is all, said and done, when he has his appearance.
He is dealing with this head on, the way he's dealt with every challenge in his life. And he's not guilty. He's innocent of these charges. We know what the charges are going to be without seeing the indictment. It's going to be racketeering. It's going to be sex trafficking. It's going to be things along those lines. This is what we've been expecting since the searches in March. He, to his great credit, he voluntarily came to New York. Not a lot of defendants do that. He came to New York to basically engage the court system and start the case, and it'll start today. And he's going to plead not guilty, obviously. He's going to fight this with all of his energy.
Somebody asked, I'm sorry, sometimes I do just say things assuming that you guys know what they mean. When they remand you into custody, they can, basically no bond. Like, they don't want you to be able to have a bond. They think you're a flight risk or you're a danger to the community. And so instead of him being able to post $20 million, which he probably has, then the government will ask that he's held into custody, that he has to be in custody as opposed to being out on bond. So it wouldn't even surprise me, honestly, that they don't ask for remand, i.e. that he go into custody.
In all of his might and the full confidence of his lawyers. And I expect a long battle. with a good result for Mr. Combs.
Do you
so
think he'll be released?
if you, I'm going to fight like hell to get him released, and he should be released with all that he's done and coming here voluntarily. And guys, I'm going to cut it short because I have to go in. All right. So thank you all very much, and I'll keep you all posted.
To Combs this morning?
Not this morning. I'm going to see him now. I was with him till 1 o'clock. So
Is he in court already?
I don't know. That's one of the things I'm going to go see. But I'm going to run, you guys.
All right,
thank you. Thanks a lot. All right, fellas. Bye, everybody. Yeah, I'll be around.
That is attorney Mark Agnifilo, happening right behind our Kara Scannell right here. And we learned a number of new things. Number one, Diddy's going to plead not guilty. Number two, they expect the charges to be racketeering and sex trafficking. And three, as you've been reporting all morning long, he's leaning to the fact that Diddy came voluntarily to New York, he claims, a few weeks ago, I should say, because they believed this was about to happen, Kara.
So there we have it. You see, his attorney said, I'm going to fight like hell for a bond. So he probably was advised by his attorney that since you knew that this is what's going to come down the pipeline, if you look like you're compliant and you come and you volunteer your appearance, they don't got to come find you, they don't have to come get you, then it looks like for purposes of bond hearing that you are, for purposes of bail, that you are not a flight risk. So this may have been a strategic, that's what I would argue if I was the government, that this was strategically done because, you know, he's going to need some type of factual proof that he is not a flight risk or a risk to the community, and the fact that he does have a lot of money and all of that. Because I think, yeah, R. Kelly was remanded, wasn't he? He never was out on bond once he got arrested. Press conference hasn't happened right yet. Just his lawyer a minute ago before going on. I want to hear what the prosecutor has to say. Yeah, me too. I haven't seen a press conference. We were on here, the Associated Press. Let me stop sharing this. The Associated Press, let me pull them back up. They are outside. They've been outside the courtroom since like 9 o'clock. Well, not the courtroom, the federal court building. Remember, I was just there. I was at that court building when I was covering Bishop Lamore Whitehead. This is exactly where I was at when I was going live for you guys. I was right in front of this courthouse. New York is a different place, honey. I said it was a very interesting experience because our courthouse here in Michigan, they're very strict. Our federal courthouse is like, you can eat off the floor. It's barely people in the hallways. Their dockets are like, you know, they keep their dockets moving. It's just a whole different world. New York, it was like so many people at this court. Everybody was walking the hallways. The elevators was barely working. You had to wait 20 minutes for one elevator at times. It was just a whole different experience. Thank you, Pensy. You said great coverage. Thank you so much, Pensy Lola. God bless. I thank you so much. And Teddy's mom, thank you for the super chat. You said thank you for all you do. HFG said, I'm so glad that you're live right now. I was just thinking that I need to hear from Pam about this Diddy arrest. Thank you. Pam was asleep. I'm sorry. When he got arrested, so when people were telling me when I woke up at 1 o'clock, I was like, well, I'll wait for the indictment to come down. I'll just watch the docket and see when it's unsealed. And that's what I did. We looking like it's going to be a press conference. Let's see. Thank you, Shaby. I appreciate you. Thank you. I appreciate you. Francine, thank you. All right, I'm not going to make you guys hear all of this racket until they come on, but we're going to watch this together. Okay, I just made a few texting calls so I could rearrange I had 11 o'clock, so I had to rearrange that. And we are going to watch this here together. Thank you guys so much for supporting. You can be anywhere, and I know the YouTube streets is jumping, but I appreciate that you're here looking at this with me. It's 1,800 of you guys. I'm so grateful. Make sure you hit that like button. Subscribe to the channel if you haven't done so already. We try to stay on top of all the news from the neighborhood to Hollywood. That is our mantra over here. Miss Buckeye said, thanks, pull up. Thank you so much. Lord, I can't lie. I would not be in good spirits if I had a whole press conference about me broadcasted for the world to see. Yeah. So. Thank you to everybody that is sharing my stream. I appreciate that. Granny the Great, thank you for the super chat. You said, thank you, Pam. You work hard for us and we appreciate it. Blessing to you. Thank you so much for the support, for keeping me going, y'all. I appreciate it. Lynn, thank you for the super chat. You said, thank you for being who you are. That is so kind of you. I thank you. I really do. We are waiting on. If you guys, if you're just coming in, you may have a little bit of time to go back. I have already read the indictment that has come down against Diddy, and we are waiting on the press conference, which will be from the AUSA, which is the United States Attorney, the U.S. Attorney's Office. The A is for assistant, if you put that in front of it. So yeah, that's what we're waiting on right now. We already talked about the clip from Diddy's attorney, who basically said, hey, we knew this was coming down, just like the public pretty much knew that it was coming down. And basically Diddy moved to New York 2 weeks ago in anticipation that he's going to have to walk up in there and turn himself in. However, the attorney was thinking, hey, I'm going to get a phone call, and the phone call is going to tell me when to turn, when he's going to be turned in or when he has to turn himself in. And they didn't. They just chose to arrest him. So let me see. Where's this thing at? Thank you, LL, for the super chat. You said, Pam, I'm with you about the learned behavior. I thought the same earlier. The music entertainment was on the woman about 39 and he got banned for posting before he was back. Yes, absolutely. Okay, why they leave out? We're going to introduce them one by one. Right, so they bought the entire place. And, they got a whole
Comes press conference September 17th, 2024. Does anybody need me to keep going? Is everybody set in the back? Give me a thumbs up if you're good. 10, 9, 8, 7, 6. You just came in from the left. Are you okay? Okay. Thank you. Yeah. Thanks. We're going to be close to on time. Hey, Jeff.
Oh, okay.
Thank you, talk to me.
Send it over to Slack.
Oh, they got PowerPoint. They got pictures. This is serious. Thank you, Alice, for the cash app. Benji, thank you for the cash app. I appreciate you. They got pictures. My.
That was fast.
Okay, good afternoon, everybody. We're going to start the Sean Combs press conference in about 2 minutes. If you have any questions about presentment, I'll come back out and we'll go over timing and give you a few updates. Thanks.
Ooh, that's a lot when you got the whole United States of America versus you. That's like millions of people versus you. And ooh, that's a lot, Sean Combs. Thank you, Lisa, for the cash app, honey. I appreciate you. Man. What you say? Dancing with the Nature fired by 81 million people versus you. That's what United States means. Woo.
Morning, everyone. My name is Damian Williams, and I'm the U.S. Attorney here in the Southern District of New York. Today, I'm announcing the unsealing of a 3-count indictment, charging Sean Combs with racketeering conspiracy, sex trafficking, interstate transportation for prostitution. The indictment alleges that between at least 2008 and the present, Combs abused, threatened, and coerced victims to fulfill his sexual desires, protect his reputation, and conceal his conduct. As alleged in the indictment, to carry out this conduct, Sean Combs led and participated in a racketeering conspiracy that used the business empire he controlled to carry out criminal activity, including sex trafficking, forced labor, kidnapping, arson, bribery, and the obstruction of justice. Let me say a little bit more about the charges. The indictment alleges that Combs abused and exploited women and other people for years, and in a variety of ways. As alleged, Combs used force, threats of force, and coercion to cause victims to engage in extended sexual performances with male commercial sex workers, some of whom he transported or caused to be transported over state lines. Combs allegedly planned and controlled the sex performances, which he called freak-offs, and he often electronically recorded them. The freak-offs sometimes lasted days at a time, involved multiple commercial sex workers, and often involved a variety of narcotics, such as ketamine, ecstasy, and GHB, which Combs distributed to the victims to keep them obedient and compliant. As alleged, when Combs didn't get his way, he was violent, and he subjected victims to physical, emotional, and verbal abuse so that they would participate in the freak-offs, and that Combs hit, kicked, threw objects at, and dragged victims, at times by their hair. On one occasion in March of 2016, that conduct was captured on video and later reported in the media. Specifically, Combs kicked, dragged, and threw a vase at a victim in a Los Angeles hotel when the victim was attempting to flee. As alleged, these assaults often resulted in injuries to the victims, which took days or weeks to heal. In addition to the violence, the indictment alleges that Combs threatened and coerced victims to get them to participate in the freak-offs. He used the embarrassing and sensitive recordings he made of the freak-offs as collateral against the victims. And the indictment alleges that he maintained control over the victims in several ways, including by giving them drugs, by giving and threatening to take away financial support or housing, by promising them career opportunities, by monitoring their whereabouts, and even by dictating their physical appearance. Because of all of this, the indictment alleges that the victims did not believe they could refuse Combs without risking their security or facing more abuse. The indictment also alleges other acts of violence undertaken by Combs and others, including violence against witnesses to his abuse, kidnapping, and arson. The indictment alleges that on more than one occasion, Combs carried or brandished firearms to intimidate and threaten victims and witnesses. Now, Combs did not do this all on his own. As I mentioned, Combs has been charged with RICO conspiracy. He used his business and employees of that business and other close associates to get his way. Those individuals allegedly included high-ranking supervisors in the business, personal assistants, security staff, and household staff. The indictment alleges that those individuals facilitated the freak-offs. They booked the hotel rooms and stocked them with the supplies, including drugs, baby oil, personal lubricant, extra linens, and lighting. When the hotel rooms got damaged, they helped clean it up. They arranged for victims and commercial sex workers to travel for the freak-offs, and they delivered large quantities of cash to Combs to pay for the commercial sex workers. The indictment also alleges that they helped Combs cover up his crimes. During the March 2016 incident at the LA hotel that I mentioned earlier, a member of the hotel security staff intervened, and Combs attempted to bribe the staff member with a stack of cash to make sure that what happened was kept quiet. And as the indictment alleges, in late 2023, after public allegations were made about Combs's crimes, he and others pressured witnesses and victims to stay silent, including by making phone calls to witnesses and victims and giving them a false narrative of what they had experienced. And as alleged, Combs used others to help conceal his abuse by monitoring and preventing victims from leaving a location in order to hide their injuries, or by locating and contacting a victim who had attempted to flee. As part of this investigation, in March of this year, special agents from HSI executed search warrants at Combs's residences in Miami and Los Angeles. They also executed a warrant for Combs's electronic devices. During those searches, agents seized evidence of the crimes charged in this indictment. They seized firearms and ammunition, including 3 defaced AR-15s and a large capacity drum magazine. They also seized evidence of the freak-offs, electronic devices that contained images and videos of the freak-offs with multiple victims. And they seized cases and cases of the kinds of personal lubricant and baby oil that Combs' staff allegedly used to stock hotel rooms for the freak-offs, more than 1,000 bottles altogether. Here are some of the items that we recovered during the searches. As you can see here, this is a drum magazine, large capacity, and it contains, I believe, 59 rounds. I mentioned as well that we recovered 3 AR-15s. This is a close-up shot of one of the AR-15s, and you can see right here, the serial number has been thoroughly defaced. Another picture of more ammunition and parts of 2 AR-15s right there. Now, I want to be clear about 2 things. First, this office is determined to investigate and prosecute anyone who engages in sex trafficking, no matter how powerful or wealthy or famous you may be. No one should doubt our commitment on that. A year ago, Sean Combs stood in Times Square and was handed a key to New York City. Today, he's been indicted and will face justice in the Southern District of New York. Second, we are not done. This investigation is ongoing, and I encourage anyone with information about this case to come forward and to do it quickly. Anyone with information can call 1-877-4-HSI-TIP. I want to express my deep appreciation for the victims and witnesses who have used their voices and helped bring this criminal conduct to light. We would not be here without them. I also want to thank the dedicated case agents on the HSI Trafficking in Person Squad in New York. They have been with us since day one and have worked tirelessly on this investigation. They will continue to be invaluable partners to us. I also want to thank the incredible agents and analysts from SDNY who have also provided tremendous assistance on this case. I'm deeply grateful for their continued work. And finally, I want to thank the outstanding career prosecutors from SDNY who are handling this case. Meredith Foster, Emily Johnson, Chrissy Slavic, Madison Smizer, and Mitzi Steiner, and their supervisors, Jamie Backleeper and Jacqueline Kelly. They are members of the Civil Rights Unit in our criminal division. We created the Civil Rights Unit when I became U.S. Attorney. I'm deeply proud of their work on this and so many other cases. I'll now take some questions.
Racketeering, ABC.
Damian, thanks. The indictment describes aggressive, open, violent, hedonistic abuse that you say was recurrent and widely known. Why did it take law enforcement so long to intervene? How many women were victimized by Sean Combs and how many others were involved?
Look, our investigation is ongoing. We are committed to bringing justice to everyone who's been victimized by the defendant. I can't tell you why it took so long. I think the better focus is on the fact that we are here today. And we are committed to making sure that justice is done. Next question.
Thank you. Julia Ainsley, NBC.
Thank you for doing this. You said we are not done and that Combs did not do this alone. Do you foresee that there could be other charges related to this case?
I'm not taking anything off the table.
Janet Fisher, Newsday.
What's the difference between the sex trafficking and promoting travel for the purpose of prostitution?
Well, there are different crimes with different elements. I don't think we should get into the nitty-gritty of the legal discussion right now, but the sex trafficking, we believe, they're all serious offenses, but the sex trafficking conduct carries some significant penalties, and we are gratified that we were able to bring that charge.
One more coercive than the other?
I'm not going to be able to get into that, but you can look it up, and yes, sex trafficking, especially when it involves coercion or force, is a very serious crime, and it carries significant penalties.
Good afternoon, Darla Miles, ABC7 New York. Thank you for this press conference and for the details. 2 questions. In context of this indictment and the information that was presented to the grand jury, are you able to clarify the number of victims? It's mentioned plural in the indictment, but can you specify the number of victims just for this particular indictment? And secondly, can you provide details about the alleged arson?
Unfortunately, I'm not able to provide either. The number of victims, you are correct. We are intentional in saying multiple. The details of the arson incident are limited to what we have in the indictment and also the detention letter that we filed, which contains more details than the indictment does at various points. But we don't have anything more beyond that. Next question.
Lynn Tran, CNN.
Are any of his accomplices or associates under investigation? And additionally, could he face any more charges?
So the investigation is ongoing. That means both as to him and to anyone else who we believe committed the crime with him. Next question.
Juliet Papa.
Hi, good morning from 1010 Wins. Any indication that some of the women or victims here were imprisoned in his residences, and did he have locations where he kept them, and they were not allowed to leave? And also, he's indicted here, although there were searches and raids in LA, Miami. Why in New York?
Well, I'm biased. I'm the U.S. Attorney in the Southern District of New York. I think that we have an outstanding track record of bringing some of the most impactful, sprawling, complex, difficult sex trafficking, human trafficking, labor trafficking, you name it. The Southern District of New York can do it, and so we're very proud of that. And so the scope and complexity of this investigation isn't something that we ran from. It's something that we embrace, and we will continue to do that. As to your question about whether he imprisoned anyone, all I can say is that, I mentioned this March 2016 incident where something was caught on video, where a victim was attempting to flee, and there was violence that was associated with it.
Was that at the residence or a hotel?
That was at a hotel.
Matthew Lee, Inner City Press.
Thanks a lot. Does your office intend to seek remand, or are you reaching a bail package? And if you're willing, how would you contrast this with the R. Kelly case in EDNY in terms of the elements? Thanks.
So we will be seeking detention. We have filed a letter laying out our reasoning for seeking pretrial detention. I'm not going to be able to expand beyond what's in the letter, but it contains all of the reasoning, and it contains the law as well. There is a presumption of detention in a case like this, and we think that's warranted.
John Anise, New York Daily News.
Thank you. I was hoping to get some more detail about the searches of his residence, the guns, the cases of lubricant, and the videos. Where were they found amongst his residence? Were they all scattered around the houses in one place? So I kind of wanted to just get a better picture of how that stuff was found.
Well, look, I think that some of the details that you're seeking are in the detention letter. So, for instance, some of the AR-15s, 2 of the 3 defaced AR-15s were found in his bedroom closet in Miami, broken down into parts along with magazines with ammunition loaded in them. So some of that detail is in the detention letter. Beyond that, I'm not going to be able to get into where other items were stored.
Ben Kochman, Post.
Hey, thanks for doing this. Your office was the office that had been prosecuting Jeffrey Epstein before he died in custody. I have not read your detention memo yet. It's the first thing I'm going to do after this ends. But does the memo address, or is your office concerned with Combs's safety in custody, given what happened with Epstein?
So we are concerned with anyone's safety whenever they are detained prior to trial. It's part of our obligations to keep people safe as well. It's part of the criminal justice system. So, but I do not draw any sort of connection between Jeffrey Epstein's suicide and what may or may not happen to any other defendant while they are detained pre-trial. And of course, the decision whether to detain the defendant will be up to a judge. Our position is that pretrial detention is warranted under the law and based on the facts of this case. And I'll leave it at that.
Are some of the prosecutors on this case some of the same prosecutors that had been handling that or that worked on the Maxwell case?
So I'm not going to get into the staffing. I will say that this team, this group of AUSAs, this incredible group has been working on this case around the clock, and they've had their hands full. Next question.
Gus Rosendale, NBC News.
Good morning, sir. Combs' attorney said that his client has been cooperative with investigators. He said that this morning. I was wondering if you would have a reaction to that.
Let me just say this. I think that generally with increasing frequency, the word cooperative or cooperating has taken on tremendous elasticity and no longer really bears any relation to what the word means when we use it in a very specific context. So responding to lawful process and the like does not qualify as cooperation when we use that term here.
Mike Sisak, AP.
Thanks. To that end, was there any discussion of Mr. Combs surrendering? I understand he was taken into custody at a hotel in Manhattan last night, and maybe that wasn't the plan. Can you elaborate on how that came about and why that was?
I'm not going to be able to get into any sort of operational details as to how he was taken into custody and when. He is in custody right now. He will be appearing in court later today.
Was there any discussion of him surrendering, given they claim he's cooperating?
I'm not going to be able to get into law enforcement tactics or operations. Well, I can't get into the charging decision. It is very meaningful to us that weapons were possessed, as we allege in the indictment. Part of the reason why this conduct was so pervasive and harmful was because victims and others didn't necessarily feel comfortable denying him his wishes, as we allege, because of the presence of firearms. I should leave it there.
Thanks. Last question, Jacob Shamison.
Jacob Shamsian, Business Insider. Thank you. Given that he's the sole defendant in this case and that you allege he's part of a conspiracy that involves members of his companies, do you anticipate a superseding indictment that bring allegations against other members of his companies or other co-conspirators as well?
I can't take anything off the table. Anything is possible. Our investigation is very active and ongoing. And I think a lot of you who cover this office know that when we say such things, that developments are certainly foreseeable, but I cannot predict them sitting here today. All right, thank you, everyone.
What part of this business empire is Forfeiture?
Thank you, everyone.
Thank you.
There we have it. U.S. Attorney Damian Williams is not playing no games. He said he's not taking anything off of the table. That means there may be more people. There may be a superseding indictment, which basically means they add more charges or they may add any co-conspirators. Nothing is off the table. And he said, if you want to know what the differences are in that indictment, basically, I'm not here to be your law school teacher. I am just here to tell you what we are charging him and what we are alleging on today. And then the reporter said, well, why is it in why is it in your district? Why is it in the Southern District of New York and not in all the other districts? And he was like, because we are about that life. We handle these type of cases. We've done Epstein, we've done R. Kelly, we've done all of these people, and we are never scared. We have the manpower to take Diddy down and anybody else that decides to come over here in the Southern District of New York and mess with our people. Then there was a question that said, well, his lawyer said that he is cooperating. And of course, cooperation is something that I told you guys earlier, if you were on my stream, that I believe personally that Diddy came 2 weeks ago because he was told you will be getting indicted, and he needed to have some type of circumstances in order to show that he is not a flight risk, because it looks like he would be based on the charges itself, and also because he does have money. He has the financial capacity to flee this here country. And so I believe it was a strategic thing where his attorney said, hey, why don't you come down here and just look like you're cooperating? Well, U.S. Attorney Williams said his cooperation is not our definition of cooperation. And therefore, we have filed a letter to the judge, which is right here, where this was just filed while we were on live, of which he has asked the judge, I guess, to detain him, which I also said in the beginning of this live. I said, well, listen, the fact typically they will contact your attorney. They be in the U.S. Attorney's office. They will contact the attorney for the defendant if they know you have one and give you time to turn yourself in. So the fact that they did not do that, I said they're probably going to remand him, which means leave him in the custody. They're going to ask that he does not have a bond and be out on these here streets. So I predicted that in the beginning before we knew this letter came. But let's go over this letter right quick that U.S. Attorney Damian Williams was referring to in this press conference. I see all of your super chats and I appreciate that. I'm going to get to that in a minute. The defendant, Sean Combs, aka Puff Daddy, P. Diddy, PD, and Love, was taken into custody this morning after a grand jury sitting in the district returned a 3-count indictment charging him with crimes related to his decades-long pattern of physical and sexual violence against multiple victims, and his use of force, threats, and coercion to enact this will protect his reputation and fulfill his sexual desires. I might as well say it because we don't watch the video, and Damian Williams said it 5,000 times. So I mean, if they're gonna do something to the video on YouTube, they just are. The government respectfully submits this letter in anticipation of the defendant's appearance before the court later today, and in support of the government's request for the defendant's detention pending trial. As set forth below, there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others and the community, not to mention the integrity of the proceedings. As reflected by the gravity of the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, he remains a serious risk of flight despite the conditions offered by his counsel. Most glaringly, the defendant also poses a significant risk of obstructing justice. Indeed, and as set forth below, during the course of the charged conduct, the defendant has attempted to bribe security staff and threatened and interfere with witnesses to his criminal conduct. He has already tried to obstruct the government's investigation of this case, repeatedly contacting victims and witnesses and feeding them false narratives of events as described in detail below. There are simply no conditions that would ensure that the defendant's efforts to obstruct and tamper with witnesses will stop. The defendant therefore cannot overcome the statutory presumption in favor of detention, and the court should order him detained. Let's give a little background here. On September 17th of 2024, an indictment returned by a federal grand jury sitting in the Southern District of New York. It was unsealed, charging the defendant with racketeering conspiracy from in or about 2008 through on or about the date of the indictment in violation of 18 U.S.C. sections 1962 sub D, which is count 1, which is sex trafficking from in or about 2009 through in or about 2018, violation of 18 U.S.C. sections 1591, which is count 2, interstate transportation to engage in prostitution from in or about 2009 through in or about 2024, and violation of 18 U.S.C. count 3. Combs' use of violence, threats, and force. Since at least 2008, the defendant and other members and associates of the racketeering enterprise alleged in the indictment, which includes the defendant's multifaceted business empire, wielded the power and prestige of the defendant's reputation as a musician, entrepreneur, and figure in the entertainment industry to commit federal crimes, including racketeering, sex trafficking, and other offenses. As charged in the indictment, many of those crimes involve the sexual abuse and exploitation of women and other crimes and violence. This letter looks longer than the indictment. So he really, the government really does not want him out on the streets. Sex trafficking and abuse. Using the power and the prestige of the enterprise, the defendant lured female victims into the defendant's orbit, often under the pretense of a romantic relationship. The defendant then used force, threats of force, and coercion to cause those female victims to engage in sexual activity, which included frequent sex acts with male commercial sex workers that the defendant referred to as freak-offs. All of this right here is in the indictment that we went over at the beginning of the video. Freak-offs were elaborate sex performances that the defendant arranged, directed, masturbated during, and often electronically recorded. Freak-offs occur regularly from at least in or around 2009 through this year, sometimes lasting multiple days, and frequently involve multiple sex workers. The defendant arranged freak-offs with the assistance of members and associates of the enterprise, including employees of his business, and the hotel rooms where they were staged often sustained significant damages. The defendant ensured the victims would participate in freak-offs through coercion and violence. For instance, the defendant provided controlled substances, including ketamine, ecstasy, and GHB to female victims so they could and would continue to engage in freak-offs despite fatigue, physical and emotional exhaustion, and pain. Additionally, both during freak-offs and separate from freak-offs, the defendant subjected female victims to physical, emotional, and verbal abuse in part to cause them to engage in freak-offs. The defendant hit, kicked, threw objects at, and dragged female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and/or the injuries sustained by women at the defendant's hands. So the people at the press conference, all of the media, they were asking, well, how many people, and trying to get numbers, and the U.S. attorney kept saying, hey, this is ongoing. But according to this letter, it looks like they have at least 12 witnesses that are going to attest to the fact that he was all alleged, but they will attest to the violence that he has had towards women. The abuse was captured on video surveillance and publicly reported in May 2024. The excerpt of this video footage is attached here too as Exhibit A. So they are talking about the hotel video. So again, one of the questions in the press conference was asking about the force and keeping them in captivity. And U.S. attorney said, I am referring to that video in the hotel room that was leaked on the internet, where Diddy had to come and apologize for his behavior, because basically there was no way that you can refute the video. The defendant's assaults often resulted in serious injuries to the victims that took days or weeks to heal. The defendants also coerced victims into participating in freak-offs by controlling their careers, finances, livelihood, and/or housing, among other aspects of their lives, or by threatening to disseminate recordings of the freak-offs. The defendant used his considerable wealth and influence to make victims rely on him financially, for example, by paying for their rent or their cars, or by offering them career opportunities. Once he provided his support, the defendant repeatedly threatened to take it away to ensure the victims' compliance with his demands, including their participation in freak-offs. Indeed, victims believed that they could not refuse the defendant's demands, and they engage in freak-offs without risking their financial security or career prospects, or without repercussions in the form of physical or emotional abuse. Other violence. He got real detailed in this letter to the judge. This is the letter requesting that Diddy be detained and not be allowed out on bond. In addition to the defendant's physical, sexual, and emotional abuse of his romantic partners, the defendant repeatedly engaged in acts of violence directed towards his employees and others. As charged in the indictment, the defendant, often assisted by members and associates of the enterprise, engaged in kidnapping, arson, and physical violence, such as throwing objects at people, throwing people on the ground, and hitting, dragging, choking, and shoving others. Numerous witnesses, including the defendant's employees and others, observed or experienced violence from the defendant firsthand and sustained lasting trauma as a result. For example, in the early morning hours of December 22nd, 2011, the defendant and co-conspirator kidnapped an individual at gunpoint to facilitate breaking into and entering the residence of another individual. One. Multiple witnesses would testify at trial to the events surrounding the kidnapping and break-in, the latter of which is corroborated by police reports and other records. So they had police reports of this and nothing, huh? It sounds like it's going to be it's probably going to be some resignation of some NYPD police. That's going to be some resignations. That's probably going to happen soon. People trying to get up out of Dodge, because it sounds like to me that there was some police cover-up going on. Approximately 2 weeks later, the defendant's co-conspirator set fire to individual one's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail inside the interior. So I don't know if that's Kid Cudi, but that sounds like Kid Cudi. Police and fire department reports extensively document the arson and conclude that the fire was intentionally set. Multiple witnesses would also testify to the defendant bragging about his role in destroying individuals' one's car. More broadly, since at least 2008, allegations of the defendant's physical abuse of women and others have been publicly reported in the media, including in Hollywood blogs and on podcasts. That's us. Law enforcement reports corroborate that police responded to several instances of the defendant's violence, including assaults against victims and other individuals. More recently, there has been an outpouring of other public allegations against the defendant, including claims of threats and physical and sexual violence dating as far back as the 1990s. And in the footnote that you see, all of the cases from Joy Dickerson and Liza Gardner, all of these complaints, Don Richard, Crystal McKinney, all these people's complaints are in the footnote that they're talking about. More recently, there has been an outpouring of other public allegations against the defendant, including claims of threats and physical during as far back as the 90s. In short, the defendant's violence tendencies are widely known. However, at no point during the past few decades has the threat of public exposure or law enforcement intervention deterred the defendant from continuing his abuse. So basically what he is saying is, listen, we got police reports that the police were aware of these arsons, was aware of these threats, was aware of trying to break into someone's home. There are police reports that evidence people have filed police reports in the 90s and 2000s against Diddy, and the police have done nothing. And even though he knew that people were filing his reports, he still continues some pattern of this behavior. So even filing a police report or getting the police involved has not deterred this man over the years. Why? Because what did we learn in one of these lawsuits? Diddy would have, I think it was Don's lawsuit, Diddy would have police officers at his parties. And they felt like it was to let you know, if you go to the police, it doesn't matter, because I got the police in my back pocket. So basically, the threat of someone calling the police on you has never mattered because there's no consequence. The next section is firearms. The defendant and members of the enterprise, including the defendant's security personnel, at times carried firearms, and the defendant himself carried and brandished firearms to intimidate and threaten others. Indeed, some victims were aware of the defendant's access to firearms. On one occasion, the defendant forced a female victim to carry a firearm on his behalf, and on another occasion, he pointed the firearm at a female victim. I believe that was also in Cassie's complaint. The defendant continues to have access to guns, including illegal firearms. In March 2024, during searches of the defendant's residence in Miami, Florida, and Los Angeles, California, law enforcement seized firearms and ammunition, including 3 AR-15s, each with defaced serial numbers, as well as a large capacity drum magazine. As pictured below in a close-up image, the serial number of one of the AR is visibly bored through and obscured. So basically they have the face so you can't trace the ownership of the gun. 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet, stored broken down in parts, along with magazines that were loaded with ammunition as depicted below. One of the AR-15s had a 10-round magazine loaded with 10 rounds of large caliber .223 ammunition, while the second AR-15 had a 30-round magazine loaded with 19 rounds of .223 ammunition. Those are the pictures. That's a large capacity drum magazine loaded with 59 rounds. In addition, 6 legally purchased guns with serial numbers, some of which were stored in gun safes, were recovered from the defendant's residence. So he also had legal guns. Although these particular guns, both the legal and illegal firearms, were seized, their presence in the defendant's home demonstrates that the defendant has access to and surrounds himself with both guns and ammunition. Likewise, even if the defendant were personally restrained by the court from obtaining new firearms himself, he could retain access to them through others. And it has a footnote that certain of the firearms seized during the March 24 searches were licensed to a current member of Combs' security staff. In addition to that individual, during the course of the charged conspiracy, Combs has employed other security members with significant criminal history, including violent crimes and firearm offenses. In sum, the defendant's regular use of violence and threats of violence, as well as the coercion described above against the victims and others, fostered a culture of fear in which these individuals believed they were unable to reject the defendant's demands without subjecting themselves to physical violence or other abuse. So hopefully this answers the question when people were in the chat asking why the guns mattered. This is why the U.S. attorney is saying the guns matter. And it also matters that he should be detained, according to him, because he is surrounded by guns, which makes you a threat to those that are around you and those in your community. Combs bribed witnesses. Combs bribed witnesses and obstructed justice. Throughout the time period charged in the indictment, when the defendant faced the possibility that his violent and criminal conduct could become public, the defendant and other members and associates of the enterprise pressured witnesses and victims not to report what they saw or heard to law enforcement or to otherwise conceal the criminal conduct. For example, and as noted above, in March 2016, the defendant was captured on video surveillance striking, kicking, and dragging a woman in a public area of a hotel in an apparent attempt to prevent her from leaving a freak-off. When a member of hotel security staff intervened, the defendant attempted to offer the hotel security officer a stack of cash to ensure his silence. After the security guard refused the defendant's bribe, and after coordination between the defendant and his employees, the defendant's staff contacted other members of hotel security. At the same time, staff members were in close communication with the victim of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance video disappeared from the hotel server. Similarly, throughout the time period charged in the indictment, members and associates of the enterprise have reached out to multiple victims on behalf of the defendant to convince them not to report the defendant's abuse. Most recently, in late 2023, immediately following public allegations of certain of the defendant's crimes, including his physical and sexual abuse of women, the defendant and the members of the enterprise made repeated phone calls to victims and witnesses, during which they provided victims and witnesses with false narratives of events in an apparent effort to conceal the defendant's crimes. On at least 2 occasions, the defendant recorded those calls on a co-conspirator's cell phone, thereby attempting to obscure his involvement in the obstruction. The government's investigation is ongoing. While the indictment against the defendant was unsealed today, the investigation into his and the other co-conspirators conduct is active and ongoing. As a result of that ongoing investigation, as well as the defendant's charged conduct outlined above, including obstruction of justice and witness tampering, the government is limited in its ability to fully set forth all known details of the defendant's criminal conduct, including details of certain witness testimony. To the extent the court has additional questions about the charged offense conduct or any other information set forth herein, the government is prepared to proffer additional information on an ex parte basis. So then after U.S. attorney has went into all of the applicable facts that they believe is the reason why he should be detained, they go into the law. So under the bail reform, federal courts are empowered to order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a risk of flight. And then it has all of the case law and statutes. If you are so inclined, you can always look those up, but I'm not going to name them all here. Obstruction of justice is another ground for pretrial detention by the court. You see that case law right there. Courts in the Second Circuit have held that pretrial detention for obstruction of justice is appropriate as long as the government can establish by clear and convincing evidence that there exists a serious risk the defendant would threaten, injure, or intimidate a prospective witness or juror. So that defines, for you that don't know what they mean by obstruction of justice, that means that they may try to do as they are alleging, call witnesses and try to intimidate them or bribe them or get them not to testify or to talk to the police. That is obstruction. The Bail Reform Act lists 4 factors to be considered in the detention analysis. The first one is the nature and circumstance of the crimes charged, including whether the offense is a violation of Section 1591. Second, the weight of the evidence against the person. 3, the history and characteristics of the defendant, including the person's character and past conduct and financial resources. And 4, the nature and seriousness of the danger to any person or the community that would be posed by the person's release. The concept of dangerousness encompasses not only the effect of a defendant's release on the safety of identifiable witnesses or individuals such as victims and witnesses, but also the danger that the defendant might engage in criminal activity to the detriment of the community. He's just saying it way more eloquently than what I said at the beginning. A finding of dangerousness does not require that the defendant have a criminal history, particularly if a defendant has a history of domestic violence. Evidentiary rules do not apply at detention hearing, and the government is entitled to present evidence by way of proffered, among other means. So what they mean is typically we all have rules of evidence of which how our evidence or if it will be admissible. That's why you hear objection. That's why you hear, sustained or overruled. You can object based on certain rules of evidence of why things should not be entered into a case. Well, at this stage where you're talking about a detention hearing, they are saying that the evidentiary rules do not apply. So if it's hearsay, that's fine. If it doesn't have the proper foundation, that's fine. Where a judicial officer concludes after a hearing that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community, such judicial officer shall order the detention of the person before trial. Additionally, whereas here, a defendant is charged with sex trafficking in violation of 18 U.S.C. Section 1951. In other words, an offense under Chapter 77 of Title 18, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. So when it comes to sex trafficking, and this is what U.S. Attorney Williams was saying in the press conference that we just watched, there is a presumption that if you are charged with sex trafficking, that there is no condition or combination of condition that will assure the appearance of the person as required. However, it is a rebuttable presumption, which means that the defense, aka Diddy, and his staff or his defense attorney can present information to rebut that presumption or attempt to rebut that presumption. For the reasons set forth below, the defendant poses a significant danger to the community, both in terms of physical violence and obstructive conduct, as well as the risk of flight. This is especially true given the nature of the criminal conduct and the strong weight of the evidence. The defendant, therefore, cannot overcome the statutory presumption in favor of detention in this case. Dangerousness. The defendant is charged with serious and violent crimes. As charged in the indictment, the defendant has physically and sexually abused women and others for the better part of 2 decades. The sex trafficking charge, based on the defendant's abusive conduct, count 2, carries with it a presumption of detention. And detention is particularly supported by the facts of this case. Since at least 2008, the defendant has engaged in serious acts of violence, including forcing and coercing women to participate in sexual activity, including sex acts with commercial sex workers, by using physical force, financial pressure, emotional abuse, and narcotics. These acts described in detail above were referred to as freak-offs, among other names, and involve orchestrated sexual performances facilitated through drug use that sometimes lasted days at a time. But that is not all. As set forth in the indictment, the charges against the defendant capture significant additional violence, both spontaneous and premeditated. On numerous occasions, the defendant assaulted women, employees, and others when he became enraged by throwing objects at them, choking them, pushing them, kicking them, and slamming them against the walls and to the ground. The defendant and other members and associates of the enterprise were also capable of premeditated violence, resorting to kidnapping and arson when the defendant's power and control were threatened. The defendant's violence, whether spontaneous or premeditated, had the effect of exerting his continued control over these individuals. The defendant also carried firearms to intimidate and threaten others. Multiple defaced semi-automatic rifles were recovered when law enforcement searched the defendant's residence in March 2024, including 2 defaced rifles that had been disassembled and hidden in the defendant's bedroom closet. In short, the conduct with which the defendant is charged shows a pattern of violent and abusive conduct, underscoring his dangerousness. The disposition of violence cannot be reasonably prevented through bail conditions. The violence alleged in the indictment was not isolated. It was systematic and pervasive. The defendant abused women with whom he has a personal relationship, employee, witness to his crimes, and others. As described above, the defendant has sexually, physically, and emotionally abused long-term romantic partners for decades, including by forcing them to engage in freak-offs. The defendant has abused countless others in his orbit, and in particular women, without regard for consequences. Indeed, the defendant's abuse of women long predates the conduct charged in the indictment. To date, at least 5 women have publicly accused the defendant of violent sexual assault dating back to the 90s. Moreover, the defendant's violence and abuse often occurred behind closed doors, including in his homes, hotels where he was staying, in the private settings. He has assaulted victims, employees, and others, and even brandished a firearm at a victim in his homes. The alleged sex trafficking similarly took place in private settings, not easily monitored. Indeed, in addition to engaging in freak-offs at hotels, the defendant has at times organized freak-offs at his home or at the homes of his female victims. This is precisely the kind of violence that even strict conditions such as home incarceration cannot prevent. In sum, the defendant's long history of violent conduct makes it clear that even the most stringent bail condition will not suffice to ensure the safety of the community. The defendant is a serial abuser who repeatedly assaults and coerces women to achieve his own sexual gratification, and uses his vast wealth and position of power in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. The defendant's long-standing pattern of abusive probative evidence of the likelihood that he will continue to abuse. Indeed, nothing, not even the threat of public exposure or law enforcement intervention, has stopped his abuse. The defendant has continued to physically assault and threaten those around him, including his romantic partners, his employees, and others who happened to be present when he succumbed to fits of rage. No bail conditions can address the defendant's tendency to become violent when angry or emotional. Anyone in his presence is at risk of abuse or assault, and the defendant's physical assaults are serious, resulting at times in serious injury requiring medical intervention and long periods of recovery. Therefore, the quote, nature and seriousness of the danger to any person, end quote, is both real and specific. And it has the case law with that quote. Obstruction. As part of the charge racketeering conspiracy, the defendant engaged in obstruction of justice, including bribery and witness tampering. Given the defendant's history of engaging in obstructive conduct to conceal his criminal activity, both personally and through intermediaries, there is every reason to believe that the defendant will continue to engage in such obstruction if he's released. As detailed in the indictment, following a freak-off in 2016, the defendant attempted to bribe hotel security staff to prevent hotel security from publicly disclosing and or reporting to law enforcement his vicious attack on a woman attempting to leave a freak-off. The defendant's efforts to disclaim responsibility for that attack continued until earlier this year. A civil lawsuit was filed on or about November 16, 2023. That's Cassie's lawsuit, alleging years of sexual, emotional, verbal, and physical abuse by the defendant, including allegations describing the March 2016 incident. Following the filing of the lawsuit, excuse me, y'all, the defendant stated in no uncertain terms, quote, let me be absolutely clear. See, this is why I tell you to be quiet and don't litigate your case in the media. I understand when you're a public figure, you try to do your PR, but look at how Diddy's quote is being used against him. This is what he quoted that is quoted in this request to detain him. Let me be absolutely clear. I did not do any of the awful things being alleged, end quote. Then through counsel, the defendant, quote, vehemently denied these offensive and outrageous allegations, end quote, describing the complaint as, quote, riddled with baseless and outrageous lies, end quote. It was not until the video surveillance footage of the defendant's attack was leaked to the media months later that the defendant was forced to admit that he had in fact perpetrated the, quote, disgusting attack. Clearly, the defendant is willing to deflect, minimize, and lie and induce others to do so on his behalf to avoid taking responsibility for his own actions. This is an example of what I tell everyone, even the cases that I cover. Like, why are you talking? Stop using the media to litigate, because the litigation that you choose to do in the media is going to come to your real litigation, and it may be to your detriment. And that's what it looks like is being used against Diddy. He basically said everything in Cassie's complaint was a lie, but then when the video got leaked that presumably he probably thought didn't exist anymore, because if it disappeared off of the hotel server, then he had to come back and say, I'm not that person. I was in a dark, dark place. And now you had to admit it because our eyes don't lie. But now you look like you a liar. More recently, the defendant has directly and through intermediaries engaged in obstructive conduct related to the matters under investigation in this case. Specifically, following the November 2023 lawsuit, the defendant and intermediaries acting on his behalf reached out to potential victims and witnesses to the alleged conduct, including individuals he did not speak to regularly and had not spoken to in years, to attempt to feed those victims and witnesses false narratives about the defendant's criminal conduct. With respect to at least two of these individuals, the defendant's co-conspirators assisted in efforts to protect the defendant. For example, on or about November 19, 2023, just 3 days after the filing of the lawsuit described above, the defendant made multiple calls to another victim of his sexual abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the calls, the defendant repeatedly asked for the victim's support and, quote, friendship, and attempted to convince the victim that she had willingly engaged in acts constituting sexual abuse. The defendant also assured the victim that if she, quote, needed the defendant to, she, quote, ain't got to worry about nothing else, end quote. A thinly veiled attempt to coerce the victim into adopting and supporting the defendant's false version of events to protect the defendant. Even more concerning, since learning about the criminal investigation, including following the execution of the search warrants on his residence, Combs contacted other witnesses on multiple occasions, including other witnesses who have received grand jury subpoenas. And they just went, they already received grand jury subpoenas, so they contacted the feds immediately, probably when he contacted them. Like Diddy and his team reached out to me. The defendant's recent conduct is similar to that in U.S. v. LaFontaine, in which the Second Circuit affirmed the district court's revocation of pretrial release after the defendant in the case engaged in witness tampering. Specifically, the defendant, who was charged with multiple counts of fraud in connection with providing false claims to medical insurers, called a witness to, quote, remind the witness that a particular patient had received surgeries that the patient had not, in fact, received. So they're coming with their authority that, hey, judge, look, and United States v. LaFontaine, this is the same actions that Diddy has done. In this case, someone called one of the witnesses and said, hey, remember that this person really did receive this surgery when they didn't, in order to get them to change their story. That is called obstruction of justice. The Second Circuit affirmed the district court's finding that there was no condition or combination of conditions that would assure the safety of the community given the defendant's witness tampering, despite the fact that the defendant's tampering did not include actual violence or threats of violence. And these footnotes right here just has where you can find all of those quotes that Diddy said. It has Billboard magazine where the quote was made, CNN, YouTube channel. Rejecting the defendant's argument that the district court's finding of dangerousness was not justifiable, the Second Circuit noted that the defendant had, quote, fed the witness false testimony with the expectation that the witness would adopt it and that even stringent electronic monitoring conditions could be circumvented. Here, the defendant's conduct goes beyond what the LaFontaine court found sufficient to revoke bail. Even before being charged with a crime, the defendant has taken numerous proactive steps to tamper with potential witnesses' testimony against him. The government is aware through electronic evidence, toll records, conversations with witnesses, and other evidence that the defendant has contacted witnesses, including subpoenaed witnesses, prior to the dates on which the witness were required to appear before the grand jury. In addition, the defendant has recorded calls with at least one victim and provided, either directly or through intermediaries, false narratives of the events that transpired so that those witnesses would adopt that false testimony. Moreover, the defendant's obstructive conduct is made even more alarming by the manner in which he carried it out to evade detection. In some instances, by having intermediaries make calls on his behalf and recording certain calls on another individual's device. These deliberate actions show that the defendant was aware that what he was doing was obstructive and that his aim was to evade detection. Thinking you smarter than a fifth grader. Even the most stringent conditions, including the monitoring of a court authorized electronic device, which is basically we call them tethers or ankle monitors, would fail to ensure that the defendant would not engage in this kind of obstruction from his home, including by acting through intermediaries and using other devices. So basically, even if you get home confinement and you have to have an ankle monitor, you still have a mouth and you can still try to do these same types of activities. Either you do it yourself or through other people. And so, yeah, that condition won't even help him to be out on bond. Given the defendant's history of obstruction as well as the violent nature of the charges against the defendant cannot overcome the presumption that no condition or combination of conditions can assure the safety of the community. Sub C is he's a risk of flight, nor can the defendant overcome the presumption that he is a risk of flight. The crimes that the defendant is charged with carry significant penalties, including mandatory minimum sentence of 15 years imprisonment and a statutory maximum sentence of life imprisonment. So for those that were asking, what can Diddy face because of this? U.S. Attorney is telling you right now, he can face a mandatory minimum sentence of life in prison. I'm sorry, mandatory minimum sentence of 15 years of imprisonment and a statutory maximum sentence of life imprisonment. And then it has all of the case law. Here, the defendant is facing at least 15 years imprisonment if he is convicted. This fact alone would provide a compelling incentive for anyone to flee from prosecution, but the incentive to flee is especially strong for this defendant, who at age 54 faces the very real prospect of spending a substantial portion of the rest of his life in prison. As detailed below, the evidence in this case is incredibly powerful. As the facts set forth in the indictment and herein make plain, dozens of victims and witnesses have provided detailed, credible, and corroborated information against the defendant. These individuals include many who personally experienced and witnessed violence and other crimes at the hand of the defendant. Moreover, their accounts were all well corroborated by significant extrinsic evidence, including financial and billing records, travel records, electronic data, and communications, including extensive communications by and with the defendant himself. They said they got evidence that corroborates the statements that some of these witnesses are alleging. For example, victim testimony regarding freak-offs is at times corroborated by other witness testimony, communications with the defendant and commercial sex workers, travel records, hotel records, videos of the freak-offs, and records reflecting or indicating payment. Ooh, this is looking real bad. Similarly, a victim's physical abuse may be corroborated by, among other things, videos of the abuse. So they're saying they got videos of this abuse, photographs of injuries, reports made to law enforcement, communications with the defendant and others, and testimony from other witnesses who saw or heard about the abuse. The vast and varied sources of evidence described in detail below will be compelling evidence of guilt at any trial in this case. Thus, the serious risk of conviction provides further incentive for the defendant to flee prosecution. Moreover, in this case, risk of flight is augmented by the nature of the evidence against the defendant. The evidence against the defendant, which would be made public at trial, include substantial evidence that is highly sensitive and has the potential to significantly and negatively impact the defendant's reputation. For example, dozens of video recordings created by the defendant of freak-offs with victims. Diddy. For decades, the defendant has spent significant time and resources ensuring that his criminal conduct avoids public scrutiny. Given the potential penalties here, both incarceration and reputational harm, the defendant has every incentive to flee to avoid prosecution and public trial. And then they have their authority. That is the case, U.S. v. Madoff. The defendant's incentive to flee outlined above, coupled with the defendant's seemingly limitless resources, creates significant risk of non-appearance. The defendant's net worth is publicly estimated at being close to $1 billion. Indeed, the investigation of this case has revealed that the defendant has access to vast funds and resources, including deep reserves of cash, which would facilitate his evasion of prosecution. At least as of December 2023, the defendant had access to dozens of bank accounts, some personal and many other corporate entities, which contain millions of dollars. Additionally, as of December 2023, the defendant had over $1 million in personal cash on hand. The defendant has traveled internationally several times per year since at least 2006, and since approximately 2019 has owned a personal plane on which he has traveled internationally. And then they have a sub, let's look at the footnote for 10. Through conversations with defense counsel, the government understands the defense counsel is currently in possession of the defendant's passport, as well as the passports of several of the defendant's family members, and that the defendant is in the process of attempting to sell his plane and Los Angeles residence. See, that's why that guy over here at the Michigan Department of Corrections that got that $100 million judgment against him, he actually got an injunction. So there was a Michigan judge that allowed for an injunction to halt him from selling any of his assets. So that may have been, if you watch my video from yesterday, please go watch it. It was about the guy, Derek Smith, who got the default judgment against Diddy. Very bizarre case. We'll be back at it tomorrow for the second part of the hearing. So come on over here and join. But that attorney was like, we need this TRO to be released. We need it to be released. Remember, if you watched it, the judge was going to hold the attorney in contempt because he kept talking when the judge said, we'll continue this on another day. Now, when you have some type of any type of an order that prohibits you from selling property, which is what the guy in prison was able to do, he wouldn't have been able to even sell this plane or sell his house. So that might have been why he was so adamant, like, we need this TRO. We need to talk about it today. We need to talk about this temporary restraining order today, because it should only lasted for 14 days. So this explains a lot. In addition to his private plane, the defendant owns multiple vehicles in multiple locations. He has personal staff, including assistants, security, chefs, trainers, and others, who performs tasks at his command, including transporting him, delivering him currency, securing narcotics for him, and other tasks. And he is extraordinarily well connected both within and outside the entertainment industry. In short, if the defendant wanted to flee, he has the money, manpower, and tools to do so quickly and without detection. The defendant's lack of access to his passport or private jet would not negate the fact that the defendant could easily buy his own way out of facing justice. As discussed below, the defendant's legal team has attempted to mitigate this substantial risk of flight by taking steps such as taking his family's passports, attempting to sell his plane, and reporting his whereabouts to the government. These steps have been taken with the precise goal of crafting an argument for bail before the court. Isn't that not what I just said? That's exactly what I said. I was like, I feel like it was just my opinion that some of these moves he made wasn't really cooperation. It was, I know I'm going to have to ask for bond, and I need some facts to prove that I'm not a flight risk, because the facts are weighing against me right now. So let me take these moves, make these maneuvers so that I can argue before the judge. Hey, judge, I was here. I found out y'all were looking for me. And I said, here I go, in my cash doll voice. And I moved to New York so that I could be easily accessible. But I told you it was very interesting that they arrested him instead of allowing him to turn himself in, which led me to believe that they were going to ask to detain him or ask for remand and going into custody. That's why I came to that conclusion, because typically they will let you just come and turn yourself in. As discussed below, the defendant's legal team has okay, wait a minute. I think I read that. While the defendant may have made the calculated decision in consultation with his attorneys not to flee before any charges were filed, that calculus inevitably changes today, when an indictment charging the defendant with extremely serious offenses carrying enormous potential penalties was unsealed. He is now, for the first time in his life, facing a mandatory minimum term of imprisonment of 15 years and a maximum term of imprisonment of life, in which the government is prepared to prove the charges against him by, among other things, the testimony of dozens of witnesses and victims to his serial abuse and evidence from dozens of his own electronic devices and those of his co-conspirators. Given the serious nature of the charges, the strength of the evidence, and the defendant's access to vast amounts of resources, his risk of flight is more pronounced today than it has ever been. Let's get to the weight of the evidence. For those of you that are coming in, could you please hit the like button? We are just going over the government's memo that they sent to the judge requesting that Diddy not be allowed to be out on bond because they're saying that he is basically a flight risk, a danger to society, and you know he has a lot of we're going through all of the reasons why they feel like he should be detained. Let's go over the weight of the evidence. In considering the danger and risk of flight presented by the defendant, the court is also required to consider the weight of the evidence against the defendant. The defendant faces a strong and powerful case here, only magnifying the danger he could present to others, especially victims and witnesses ready to testify against him and the risk he flees. The evidence in this case consists of a vast amount of victims and witness testimony, electronic evidence, physical evidence, and subpoena returns, and other voluntary productions, among other things. As to witnesses, to date, the government has conducted interviews with over 50 victims and witnesses. 50. Many of whom saw or experienced the defendant's abuse. Many of these witnesses corroborate one another, and their accounts are similarly consistent with the other types of evidence discussed below. The government only expects that number to continue to grow, given that the investigation, which is now public, is ongoing. That's a big number, Diddy. 50? Okay, let me try to, I see the chat is moving really fast. Okay. Hopefully that slows it down some. The electronic evidence is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses. Setting aside devices seized in connection with the defendant's arrest, the government has obtained over 90 cell phones, laptops, and cloud storage accounts, as well as over 30 other electronic and storage devices such as hard drives, thumb drives, cameras, and surveillance systems. This electronic data comes from the defendant himself, as well as co-conspirators, victims, and witnesses, and chronicles much of the defendant's criminal activity as it occurs. The evidence also consists of physical evidence, which was seized pursuant to search warrants executed at the defendant's residence in Los Angeles and Miami, as well as on his person and the persons of certain co-conspirators. In addition to the firearms and electronics discussed above, the physical evidence also includes other evidence of freak-offs, including over 1,000 bottles of baby oil and personal lubricants. That's a lot of lube. Finally, the evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 100 entities and individuals, including communications providers, tech companies, social media companies, bank and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendant's companies and wealth management firm. Hold on one second. Got to take one quick break. Sorry about that. I'm supposed to technically be working. Let's see where we at. Finally, the evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 100 entities and individuals, including communications providers, tech companies, social media companies, banks, banks and other financial institutions, airlines, hotels, car services, and other travel related companies, escort services, and even the defendant's companies and wealth management firms. Together, this evidence, as well as other evidence gathered, powerfully demonstrate the defendant's guilt and counsels in favor of detention. I hope he has a Johnny Cochran like team together, because he's going to need several defense attorneys. Because as you guys saw, if you watched the press conference, it looks like 5 attorneys plus 2 supervisors are on this case. 5 prosecutors or AUSAs on this case, and they are all women. I did notice that as well. They are all women that are prosecuting him. The defendant's proposed bail package is insufficient. So he must have proposed a bail package. So let's get into it. For all the reasons set forth herein, there is no bail package that can reasonably assure the safety of others in this case, where the defendant has engaged in a decades-long pattern of violence against women and others and has used his wealth and power to ensure that his criminal conduct goes unpunished through manipulative and obstructive conduct. In particular, the bail package proposed by defense counsel is insufficient because it fails to adequately protect others from the defendant's violence, impose measures to prevent and detect obstruction, or prevent the defendant from assessing his vast resources, including millions of dollars in cash, to evade prosecution, or dissipating those assets to avoid financial penalties for his crimes. Defense counsel has proposed certain bail conditions, including home detention with electronic monitoring and a $50 million bond. So Diddy has proposed that he have home detention with the ankle monitor and a $50 million bond secured by the defendant's Miami property. These conditions are plainly insufficient to address the legitimate concerns set out above. In particular, given the defendant's history of engaging in obstructive conduct, the court must reject the insufficient conditions proposed by defense counsel, which do nothing to prevent and detect such conduct. For example, and they give him more authority, in U.S. v. Ferranti, a case in which the defendant was charged with witness tampering and where obstruction remained an ongoing concern, the Second Circuit reversed the district court's release of the defendant on bail conditions because the $1 million bond, which was to be secured by properties owned by the defendant and members of his family, only deterred flight, not danger. More specifically, the Second Circuit found the district court's bail condition intended to address witness tampering, which was a general prohibition that the defendant was not to commit a crime or intimidate a witness. So again, what they are saying, the government is saying, hey, he can be at home all he wants. That's just to avoid flight risk. But there are other reasons why a person should not be on bond, which also includes intimidating witnesses or threatening the community. That does not, or being a danger to community. This conditions with ankle monitor and being at home does not necessarily deter that. And then they have the case law, which backs up that statement. Notably, the defendant's previously proposed conditions do not include provisions related to his access to electronic devices, which is outlined above the defendant uses to engage in obstructive conducts, nor do the proposed conditions include information related to or restrictions on access to his vast resources, including multiple personal bank accounts in the name of the defendant's business, and deep cash reserves, which could facilitate the defendant's flight. Similarly, the proposed conditions fail to protect against dissipation of assets, which may be subject to forfeiture or penalties on the charges of the indictment. Finally, the proposed conditions do not include conditions that will limit the defendant's potential to engage in violence or abuse, such as drug testing and treatment and surrender of all firearms. In conclusion, In conclusion, as set forth above, the defendant poses an ongoing and significant danger to the community as repeatedly engaged in obstructive conduct and presents a serious risk of flight. The government respectfully submits that the defendant cannot meet his burden of overcoming the statutory presumption in favor of detention. There are no conditions of bail that would assure the appearance and compliance of the defendant or the safety of others. Accordingly, any application for bail should be denied. So that is the reasoning why they are asking for Diddy to, or Sean Combs to be detained. Let's see if something else happens since we've been on here, because it seems like things are just moving on this here case. Let's see. See if something else happened. Is it another letter? Yeah, let's see what this letter is. And it's a bunch of exhibits. Okay. Okay, so here Sean Combs has submitted what he's asking for. We kind of know now because we just read the letter. Let's see. Sean Combs, through his counsel, submits this letter to the court for release on certain specified conditions. Yesterday evening, Mr. Combs was arrested on an indictment charging him with the following offenses. For the reasons set forth below, we ask this court to release Mr. Combs pursuant to our proposed bail package. This letter will walk the court through a series of actions taken by Mr. Combs over the past 6 months that prove that he is not a risk of flight or a danger to anyone in the community. These actions prove that Mr. Combs is eminently trustworthy, that he is demonstrably committed to showing his innocence in court in the context of this case, and that he should be released on the conditions proposed in order to do so. Y'all ready for this? The first thing the court should know is that when it became apparent to his counsel that Mr. Combs would be at some point soon be formally charged, he did something extraordinary. He left his home in Miami and traveled to, in italicized because they're trying to emphasize it, New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York, offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. Even though Mr. Combs came to New York, authorized his lawyers to tell the government of his location, and offered to self-surrender, the government effected an arrest last evening. This we know is the government's right. However, that he traveled to New York to self-surrender is also something the court should consider. This was not the first action Mr. Combs took to show his trustworthiness and lack of flight risk. Indeed, it is part of a pattern since even before the March 25th, 2024 searches on Mr. Combs' residence. Mr. Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking and other offenses. Knowing for these many months that he would be indicted, Mr. Combs has done everything, as will be set out below, to work with the prosecutors in ways that are unusual, if not unprecedented. In light of these circumstances, he can rebut the presumption of detention here due to his extraordinary actions in this here investigation. Mr. Combs should be released on the conditions proposed so that he can fight this case in the court effectively. I know y'all want to see my face because I know the intellects. But I jumped on this live and my hair is all over the place. So I'm not going to have you guys making memes about me. It's not going to happen today or no day. The proposed package. The defense proposes the following bail package: a $50 million bond. B, co-signed by Sean Combs, his mother, his sister, the mother of his oldest daughter, and his 3 adult sons. I don't even know who his oldest daughter is. That's interesting. Secured by the equity in Mr. Combs' residence located, it got his address. We ain't putting that on there. The appraised value of the home is $48 million. The home is unencumbered. In anticipation of this bail hearing on August 20th, 2024, Mr. Combs paid off the remaining mortgage of about $18 million so that the home could be used to secure a bond and be free of a mortgage. Sub D, secured by the equity of Mr. Combs' mother's home located, don't want to put her name on there. Mr. Combs' travel will be restricted to the Southern District of Florida and the Southern District of New York to attend court, meet with his counsel, and attend medical appointments, which we will address to the court in a separate sealed submission. He's like, I'm not gonna let the public can't see that. We about to seal that. As well as the Eastern District of New York or the District of New Jersey, only to the extent that his travel to and from New York involves an airport in those districts. F, Mr. Combs' passport was surrendered to his counsel on April 1st, 2024. His counsel advised the prosecutors of this fact in an email dated the same day. Counsel will provide the passport to pretrial services. The passport of the following family members who have already surrendered their passports to counsel after the raids on Mr. Combs' home. So then it lists all the family members, even the baby. They've all surrendered. They all can't go anywhere out the country. Since at least April 2024, Mr. Combs has been making efforts to sell his airplane. We informed the government of these efforts on May 2024, as explained further below. Just this weekend, Mr. Combs entered into a letter of intent with the party to sell it. Mr. Combs understands he is not to travel to Los Angeles, where the plane has been located this week, and further that the plane is not to be brought to any district in which he is located until it is sold. I, home detention with GPS monitoring, and J, all other standard conditions of pretrial services. The history of this investigation shows a great degree of collaboration between the government, Mr. Combs, and his counsel, which should weigh heavily in this court releasing him on the conditions proposed. Listen, his attorney is out here fighting, man. He is windmilling. He is out of breath right now, the way he's sitting up there throwing these hits out there. On March 13, 2024, counsel for Mr. Combs emailed the assigned assistant United States attorney. In this introductory mail, counsel identified himself as counsel for Mr. Combs and stated that he wished to speak with the prosecutors and share information about Mr. Combs and the matters under investigation. After not hearing back from the AUSA's counsel, again emailed the prosecutors on March 18, 2024. Counsel did not get a response to this second email either. Not they left the counsel on read. On March 25th, 2024, search warrants were executed at Mr. Combs' places of residence in Miami and Los Angeles. That's very interesting. How on March 13, 2024, counsel for Combs emailed the AUSA saying, I am counsel for Combs. They didn't respond. Then they emailed again March 18th and didn't respond. But then the warrants were not executed till March 25th of 2024. So that leads me to believe that they knew that this stuff was coming down, that the warrants were coming. Because why are you contacting the AUSA? You just randomly say, hey, I just want to let you know that this guy is my client. Like, why would you randomly do that? It's very interesting. In addition, he was removed from his airplane and searched. The searches of the residence were unusually public and particularly heavy-handed. The agents had assault rifles trained on the heads and the chest of his children, who were then handcuffed and brought before news cameras and a press helicopter. On the day of the searches, counsel called the prosecutors and they spoke for the first time. So they didn't talk to them until after the warrants were executed. They was like, we're going to leave you on read, and then we're going to do what we got to do. And then after we get finished, then we'll get back to you, counsel. Counsel indicated that he would accept service of 2 grand jury subpoenas to Mr. Combs' businesses. On April 1st, 2024, counsel takes possession of Mr. Combs' passport. About a week following the searches on April 1st, 2024, counsel took possession of Mr. Combs' U.S. passport. As noted on this same day, counsel advised the AUSAs of the fact that counsel had Mr. Combs' passport and that we would not return it to him and that he would not leave the country during the pendency of the investigation. We have, in fact, maintained the passports, and Mr. Combs has not, in fact, left the country despite knowing the investigation was ongoing, despite having a plane at his disposal, despite not being charged with any crime. Counsel agreed to advise the government of all domestic travel. Moreover, counsel advised the government that if Mr. Combs intended to travel domestically, counsel would inform the AUSA. These 2 promises have also been kept. For example, on June 9th, counsel advised the AUSAs that Mr. Combs was traveling from Miami to Los Angeles to go on a road trip with his children. In addition, we provided the AUSA with information about when his flight departed and when it landed. On June, sir, do you not think that if the government is looking at you, they don't have people watching you and where you go and when you book a flight? They really didn't need you to tell them this, but I get what you're doing right here. In addition, we provide the AUSAs with information about when his flight departed and when it landed. On June 29, 2024, counsel emailed the prosecutors that Mr. Combs was flying to Wyoming via a chartered aircraft. On July 5th, counsel emailed the prosecutors that he was traveling back to LA. 2 days later, on July 7th, when he traveled back to Miami via a chartered aircraft, we again emailed the AUSA. In addition, when Mr. Combs planned travel but not take those trips, we notified the prosecutors of that as well. Counsel advised the government of Mr. Combs' efforts to sell his airplane. On May 21st, 2024, counsel advised the AUSAs during a phone call that Mr. Combs had commenced efforts to sell his airplane. We followed up on that conversation the next day. On May 22nd, 2024, with a letter to the AUSA, the efforts were underway to sell the aircraft and reminded the AUSA that counsel continued to be in possession of his passport. Now, all these exhibits they have attached to show emails and I guess records and all of that, they are attached to this. I didn't download them though, because this was just spontaneous. I'm just looking at the docket. Over the past several months, there have been several potential buyers for the airplane, and at least 2 buyers have signed a letter of intent to purchase the aircraft. Just this weekend, a buyer for the aircraft and representatives for Mr. Combs executed a letter of intent. Due to the nature of this asset and the amount of inspection and due diligence that is required for a purchase, it is not a simple asset to offload. In advance of the plane being sold, which it eventually will be, we have agreed to keep the airplane in Los Angeles while Mr. Combs resides in his home in Florida if it is not being chartered. Coincidentally, and not at Mr. Combs' request, last night, the airplane was chartered on Part 135 flight from Los Angeles to New Jersey. Mr. Combs had no advanced knowledge of the flight, nor did he possess any control over its movement last night. Obviously, Mr. Combs agrees to not go to any state in this case, New Jersey, in which his airplane is located pending its sale, which is actively being pursued. Mr. Combs voluntarily relocated to New York in advance of his arrest. I can't. Once it became apparent to counsel that Mr. Combs' arrest was imminent, he promptly relocated to New York City. On September 5th, 2024, Mr. Combs arrived in New York, and counsel immediately informed the government of Mr. Combs' whereabouts. Counsel offered to continually share Mr. Combs' location with the government. Since arriving in New York on September 5th, Mr. Combs has been staying at the Park Hyatt, New York. Due to bookings made at the Park Hyatt prior to Mr. Combs' reservation after today, September 17, he would no longer be able to stay at the Park Hyatt. Well, it sounds like they're trying to make his new home for a little while be detained. That's what it sounds like. So he may not have to worry about rebooking these reservations. Accordingly, Mr. Combs had a reservation to stay at the Carlisle Hotel starting today. He might want to cancel that because I don't know, Diddy. It's not looking too good right now. Since Mr. Combs relocated to New York earlier this month, counsel has been looking for a 1-month rental for Mr. Combs in New York City. Despite counsel's persistence, it has been challenging to find a rental for many reasons, including because of the numerous events occurring in New York City. For example, the U.S. Open, Fashion Week, and the UN Summit. And some landlords' discomfort with having Mr. Combs as a tenant giving the investigation. You think? Can you imagine? Like, hi, I'm here as a representation of my client. Who is your client? Sean Combs. He's looking for a rental at the residence for a month. There is no room at the inn. Have a good day, counsel. No, we don't have any. What? You found that in the paper that I had a vacancy? Oh, right before you got here, we just booked this. Right before you, when I say immediately before you pulled up, we booked this. It's so ironic. I'm so sorry for Mr. Combs. I'm sorry. I hope good luck to him though. Tell your client I said good luck. Okay, let's go ahead. Counsel advised the government. Oh, I'm sorry. I had one more sentence there. I got a little carried away with my reenactment. Last night, counsel had scheduled a viewing of a potential apartment. However, because of Mr. Combs' arrest, counsel and Mr. Combs obviously were not able to view the rental. Wow. He was looking for a house last night. He was viewing the rental, and then he got arrested. Counsel advised the government that it was in possession of the passports of members of Mr. Combs' family. On June 13, 2024, counsel informed the government that we possessed Mr. Combs' mother's passport. We have also informed the government that we possessed the passport of his 4 daughters, all of whom were minors at the time we took possession of the passport. Counsel's assistance to the government concerning subpoenas. As stated above, counsel accepted service of 2 subpoenas directed at several of Combs' businesses on March of 2024. Separate counsel for the entities filed a motion to quash those subpoenas on April of 2024. In May of 2024, upon becoming sole counsel in connection with the criminal investigation of Mr. Combs, we advised the court that it will withdraw that motion to quash the grand jury subpoenas, and instead that the parties would meet and confer with the government to minimize the number of requests on which the parties disagreed. Counsel agreed to begin gathering documents responsive to the subpoenas. For the past several months, counsel for Mr. Combs and the AUSAs have had regular discussions about what documents we had, what we did not have, and in regard to the documents we did not have, where the government may be able to find such documents. We did this for 2 reasons. First, there was nothing in counsel's estimation that would estimate evidence of Mr. Combs being involved in any federal crime. Second, we wanted to be appropriately helpful to the government in their investigation. To that end, the Combs entities have produced over 144,000 pages of documents to the SDNY in compliance with the subpoena. Paying off the mortgage, the 2 West Star Island in Miami. As noted in the discussion about the bail package, August 2024, Mr. Combs caused the outstanding mortgage to be paid on his primary residence in Miami. This payment of about $18 million was for one reason alone, so that he would have this $48 million residence free and clear of any encumbrances, so they can be used to secure bonds. We submit this is a truly extraordinary measure that shows resoundingly that Mr. Combs is appropriately focused on defending this case on the merits in this court. Whew. His attorney is doing the best he can. That's all I can say. With the facts given, you, sir, are doing the best that you can right now. Your client is innocent until proven guilty beyond a reasonable doubt. We do maintain that over here on this platform. But when the feds say they got video and audio and phone records and all of that, you believe them. There is a reason why their success rate is very, very high. There is a reason why we celebrate, and I celebrate with my colleagues. Like I had one colleague who beat a case in federal court, criminal, a month ago, and I was like, you deserve like a 5-star meal, because that doesn't happen very often. So there's a reason why their conviction rate is very high, because they come with evidence on evidence. So it's like they don't just have your phone, they'll take your text in your phone. Then they'll get the person that you were talking to be a witness. Then they'll get a marshal that's in phone data to come and tell you where your phone was. Then they'll tell you all the cell phone data. Then they'll extract it up out of there. Then they'll get your phone records. Like they will corroborate on top of their corroboration. Okay, that's what they do when you deal with the federal government. Let's go on. So then they go on to the legal aspect. As you guys see, it looks like about 6 pages worth of all the great things that the attorney is saying that Diddy did that show that, hey, I'm trying to cooperate. I done gave up my passport. I'm selling my plane. I took any type of lien off of my home. I voluntarily moved to New York. My counsel has been trying to talk to the AUSA since March, even before the subpoenas were, before the search warrants went to search my homes. I've done all of this stuff. So that's basically what they're laying out if you just came in. So now they're getting to the legal standard of this. Because Mr. Combs is presumed to be innocent, which he is, counsel, he is. The Supreme Court has observed that liberty is the norm and detention prior to trial or without trial is the carefully limited exception. And that is the U.S. Supreme Court. They came with the big dogs. They came with the United States Supreme Court, which is the highest court of this here land in these divided states of America. As the Supreme Court recognizes, the function of bail is limited. The underlying goal is securing the presence of the defendant rather than the sum of the bail. And then it has the case law. When deciding an issue of pretrial release, the Second Circuit has noted that the court should bear in mind that it is only a limited group of offenders who should be denied bail pending trial. Then it has some case law from the Second Circuit. Indeed, the Bail Reform Act requires that the court impose the least restrictive condition or a combination of conditions that will reasonably assure the appearance of the person as required in the safety of the community. While there is a presumption of detention in sex trafficking cases, this presumption is rebuttable. That is underlined and it is bolded, so that is for emphasis. It's rebuttable. Although there is a presumption, we can rebut it. And Diddy's attorney is saying, I have the facts to rebut it. Look at my client's actions. Look at all the things he did to show that he is trying to cooperate and to be able to defend himself and claim his innocence at the time of trial. The presumption imposes on the defendant a burden of production, while the burden of persuasion remains with the government. Although this burden is not heavy, the defendant must introduce some evidence contrary to the presumed facts. A defendant can satisfy this burden by coming forward with evidence that he does not pose a danger to the community or a risk of flight. Even if the defendant presents some evidence satisfying his or her burden, the presumption of favoring detention does not disappear entirely, but remains a factor to be considered among those weighed by the district court. And then it has a case defining the burden shift. I'm not going to go over that. The Section 3142 sub G factor, acknowledging that sex trafficking has a rebuttable presumption of detention. We know that. We learned that from the AUSA's brief. We learned that in their letter. There is a rebuttable presumption. Mr. Combs can rebut such a presumption with evidence that he does not pose a danger to the community and is not a flight risk. An analysis of this section factors weigh in favor of releasing Mr. Combs on these conditions. So they're going to weigh the factors just like the government weighed the factors on their behalf. And when they say they're balancing the scale, he's going to say it balances in favor of his client, which is Sean Combs. The nature and circumstances of the defense. Mr. Combs is charged with 3-count indictment. The first count charges Mr. Combs with racketeering conspiracy, Count 1 alleges that Mr. Combs relied on employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other things, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice, and that the conspiracy lasted from at least in or about 2008. See, this is what's interesting. Maybe they were writing this. Whoever at this office must have been writing this while the attorney for Combs was in court. Because we saw at the beginning that his attorney said he had not seen the indictment yet, but he was aware of some of the allegations that they presumed it was going to be. So apparently, I'm going to assume perhaps there were people at his office that was waiting on the indictment or whatever, and they were able to do this morning or something. Because he just said he hadn't seen it, but now he's citing paragraphs of the actual indictment. As alleged, the pattern of racketeering consisted of multiple acts involving kidnapping in violation of California law, B, multiple acts of arson in violation of California law, C, multiple acts of involving bribery in violation of California law, D, multiple acts of indictable under 18 U.S.C. section 1512 relating to tampering with a witness, victim, or an informant, E, multiple acts of indictable under 1589, and 2, relating to forced labor, F, multiple acts indictable under 18 U.S.C. 1591 and 2, related to sex trafficking, sub G, multiple acts indictable under 18 U.S.C. section 2421, 2422, and 2, related to transportation and inducement to travel for purposes of prostitution and other illegal sexual activities, and F, multiple offenses involving the possession with intent to distribute all of these different narcotics, man. Cocaine, oxycodone, alprazolam, I'm probably saying that all jacked up, meth, HG, oh goodness, what is that? Gamma hydroxybutyric acid, ketamine. And then it has all of the different USC sections. Distribution and possession with intent to distribute and conspiracy to commit the same. Aiding and abetting, willfully causing. Indictment paragraph 13. Count 1 also includes a notice of special sentencing factor in connection with Mr. Combs' alleged agreement. That means a force, threats of force, fraud, and coercion would be used to cause the person to engage in a commercial sex act. Diddy's attorneys are working very, very hard. They are working very, very hard. We got the civil side with all these lawsuits, and then we got this criminal side. The second count charges Mr. Combs with sex trafficking by force in violation of, y'all see the U.S. code. Count 2 alleges that from at least in or about 2009 up to and including in or about 2018, Mr. Combs recruited, enticed, harbored, transported, and maintained in person victim 1, and attempted, aided, and abetted, and willfully caused victim 1 to engage in commercial sex acts, knowing and reckless disregard of the fact that victim 1 was engaged in commercial sex acts as a result of force, fraud, and coercion. That's indictment paragraph 16. The third count charges Mr. Combs with transportation to engage in prostitution in violation of 18 U.S.C. You guys see which one it is. Count 3 alleges that from in or around 2009 up to including in or about 2024, Mr. Combs transported, aided, and abetted, and willfully caused the transportation of female victims and commercial sex workers on interstate and foreign commerce on multiple occasions with the intent that they engage in prostitution. That's in paragraph 17. The indictment also includes forfeiture allegations. Defendant's history and characteristics. Okay. Mr. Combs' history and characteristics are best demonstrated by the way he has responded to the investigation from the very inception to his most recent decision to travel to New York when his lawyers told him that the case could soon be starting. He has never run from a challenge, and he will not run from this one. Instead, he takes these challenges head on. He moves towards them confidently and with the assurance. They look like they made a mistake. that something is on the side. I don't know. These are not merely the words of his lawyer. Rather, the actions of Mr. Combs over the last several months conclusively prove this. Aside from this action, since the inception of this investigation, Mr. Combs' character is shown through his demonstrated contributions to society in several important areas. First, he has given generously over his entire life to charitable causes. To name only a few, since founding Bad Boy Entertainment in '93, Mr. Combs has actively supported and donated millions to after-school programs and organizations like the Boys and Girls Club of America. His commitment stems from the positive influence such programs had on his own childhood, inspiring him to give back to similar initiatives. He has also supported organizations including the National Foundation for Teaching Entrepreneurship, further emphasizing his dedication to creating opportunities for young entrepreneurs. A cornerstone of his philanthropy is education, and he fulfilled a lifelong dream when he, with the partner, opened Capital Preparatory Harlem Capital Charter School in 2016 to provide high quality education to inner city youth in New York City. Didn't they denounce him or something when all this stuff started happening? If I recall correctly. The success of this initiative led to the launch of Capital Preparatory Bronx Charter School in 2020, with Combs donating $1 million to support its development. These schools are part of this broader commitment to education, which includes significant contributions to historically Black colleges and universities, such as $2 million to Howard University and $1 million to Jackson State University in 2023. Mr. Combs has also been proactive in health and disaster relief efforts, having raised over $2 million for New York City public schools and hosting a virtual dance-a-thon that raised more than $4 million to provide personal protection equipment to healthcare workers on the front line of the COVID-19 pandemic. Particularly important in an election year is Mr. Combs' contribution to mobilizing young voters with the quote, "Vote or Die" slogan through Citizen Change, which he founded to significantly increase political awareness and youth voter turnout. You know, they can kind of try to twist that out, that you try to get into the politics because you know how important it is to be cool with people in big places, because over the years, it sounds like plenty of people have filed police reports. However, nothing has really happened to you, even those people have filed police reports, what leads me to believe, and again, this is just an assumption, that there were people in this department who you really did have in your back pocket. So it would behoove you to try to be cool with people in the political arenas because they make laws, create laws, and make decisions. You know what I'm saying? So, you know, you doing this vote or die, you know, yeah. Second, a few people have done more to advance the cause of Black people in the music. Second, few people have done more to advance the cause of Black people in the music, entertainment, and fashion industries than has Sean Combs. While he has always been controversial, he has always championed minorities and underrepresented communities. Sir, do you not see what these people are saying they were subjected to when they were working under him? As the chairman of Combs Global, Mr. Combs has used his platform to create, quote, the Excellence Program, an internship initiative with Endeavor in July 2021, a major initiative designed to provide development opportunities for aspiring executives in entertainment, marketing, music, and fashion from underrepresented communities. Mr. Combs' philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award from the National Action Network in 2016. Al Sharpton, time for y'all to start rescinding some of these awards, huh? Can you rescind old awards? I don't know. The Superhero Award from Room to Read in 2017, the Child of America Award from the Carver Foundation in 2018, and in 2023, the Icon Award from the Apollo. Through his multifaceted career, Mr. Combs has not only created thousands of jobs, this is part of this indictment, sir, these thousands of jobs, including valuable internships for young professionals, but has also supported minority and women-owned businesses, leveraging them as key suppliers and vendors for his enterprises. Counsel will be prepared to address the factors of dangerousness to the community and weight of the evidence in court at 2:30. So now we know Diddy is scheduled to appear this afternoon at 2:30 p.m. So we might be back. The proposed bail package addresses any issues with flight and danger to the community. In light of the proposed conditions, the actions Mr. Combs had already taken regarding the investigation, and Mr. Combs' lifetime commitment to live up to his obligation concerning every challenge he has ever faced, he should be released to fight this case in court and prove his innocence. Sean Combs has never evaded, avoided, eluded, or run from the challenges in his life. He will not start now, as he has handled every hardship. He will meet this case head on. He will work hard to defend himself, and he will prevail. Recognizing that a bail hearing is not the time to defend the merits of criminal case, it is relevant to bail if the defendant has made a clear commitment to defend an eminently defensible case. This is such a case. Finally, several courts in the district have recognized that the conditions at Metropolitan Detention Center in Brooklyn are not fit for pretrial detention. Listen here, I followed the Bishop Lamar Whitehead case, and literally his attorney, when Lamar Whitehead was found guilty, he was remanded after he was found guilty. He was out on bond before that, but he ended up being remanded once he was convicted of an actual charge that required remanding. There was a requirement. And so when he went and was remanded, his attorney, when she tried to counter the government's position that he should be remanded, that is pretty much what she was saying as well, talking about the conditions in the Brooklyn pre-trial detention center, Metropolitan Detention Center in Brooklyn. That was one of the arguments that she had, and listed a bunch of the statistics on what it was and how the food was, and the client lost weight and all of that, and that still was not persuasive to the court, because the government basically provided information that a lot of the statistics were outdated statistics that they were presenting. Just earlier this summer, an inmate was unalived. At least 4 inmates have died by suicide there in the past 3 years. Numerous courts in the district have raised concerns with the horrific conditions of detention there. So then they're showing, United States v. Chavez, describing the conditions at MDC as dreadful and longstanding, and noting that the issues with food and contamination and hazardous physical conditions were an ongoing tragedy. US v. Morgan, describing the MDC as dirty, infested with drugs, and plagued by violence. US v. Boyd, describing overcrowding, staffing issues, and lockdowns at the MDC. Describing MDC conditions as disgusting and inhumane as anything I've heard about any Colombian prison, but more so because we're supposed to be better than that. Courts in the Eastern District of New York have shared the same concerns. So they have more court cases. US v. Forbes, they say the court noted it was worried about MDC's conditions as one of the reasons for sentencing the defendant to non-custodial sentence. US v. Colucci, which is a August 5th, 2024 case, so that's pretty recent, sentencing a defendant to 9 months in prison, but ordering that if BOP designated the defendant to the MDC, the court would vacate the sentence and resentence to home incarceration. Oh, wow. For the reasons set forth above, we move this court to release Combs under the conditions set forth above. Thank you for your consideration. Respectfully submitted, Mark. You guys see that last name? I can't pronounce it. Man. So there's that. Let's see. And you make sure it's nothing else, shoot, before we get off of here. I just came on here to read the indictment. We done been on forever. Let's see what else we got. Somebody said, I'm gonna get a let's see what else we got. Don't go nowhere. Hold on. We in this together. We in this for the long haul. Let's see. We got a motion for bond file. See what I'm saying? They working. Just another 10. Okay. They must have refiled what we just did, and they must have took out all of those mistakes. That was it. It's not, doesn't look like it's anything new on here. Looks like they just took all those mistakes out. Apparently I clicked too fast, before they were able to correct themselves. And so I think that's what we have now. Anybody have any updates since I've been on here, huh? Anybody have any updates? Melissa said, thank you, Pam, for your time reporting this story thoroughly. Thank you so much for the super chat. I appreciate. Leandria, thank you so much for being a member for 5 months. You said always the charities. Oh, absolutely. You didn't know? Top of the boot, thank you for becoming a member. Outstanding task, thank you for becoming a member. Welcome to the intellects to delicious. Thank you, child. That name. Thank you, ABK, for the super sticker. Pamela, the wire designer, thank you for the super chat. You said Diddy will be passing gas like Wade Wilson did during his interrogation. You know what? Leandra, thank you for gifting a membership. Welcome to the new intellect. Cheek said, thanks, Pam. Your insight and foresight are always on point. Thank you for the generous donation to the channel. I appreciate that. Crystal said, so glad I was able to catch this live. I can always look to you for the unbiased truth. Thanks for all you do. Thank you. Kwame, thank you so much for the super chat. Preppy Princess said, thank you, Pammy Pam. Thank you, girl. Healthy and Happy Ramaya said, why is Luther Vandross song Bad Boy playing in my head right now? I wonder if they're gonna be singing every step I take, I'll be missing you. That's gonna be the next song they're gonna be singing for themselves. Every step I take, every move you make, I'll be missing you. Thinking of the day when you went away. We gonna see if that's what happened at 2:30. E Boogie said that cot damn Pam be knowing what she talking about. Thank you so much. I appreciate that. Talk to me. Thank you for the super sticker. Orchard, thank you so much. I appreciate the support. Simply Me says, so after the suit, he didn't get rid of the videos. Apparently not. That's what I'm saying. What did you keep them for? Like, were you like looking at them later? You like, let me see. Take that. Like, what are you keeping these videos for? I don't know. Thank you for bringing us the T Detroit style. Thank you, Black Hourglass. Talk to me. Thank you so much for the super chat. You said, Pam, I'm with you about the learned behavior. I thought the same earlier. The music and entertainment industry has long been rumored to be fueled by dirty money. He got game for those who came before him and passed it down. Absolutely. He didn't come up with this on his own. You just don't come out of the womb that bold. Thank you for being who you are. Thank you so much. I think I read all of these. Thank you guys so much. It was a lot of you in the chat, and I appreciate it. So if you haven't subscribed to the channel and you like our content, make sure that you subscribe. I would appreciate it. If not, if you just enjoyed this video, like it so that other people can see this video and know that we are here. We have been here for three hours, and some of you guys have rocked with me the whole time. So Diddy is set to appear at 2:30, and if he appears at 2:30, we'll probably be back here at around 3 o'clock when his lawyer come out, and we'll see if he's with his lawyer or not. I guess that'll be the true test. If he comes out and does the press conference with him, or if he comes out all somber, like, they got him, y'all. They got him. They made him go, and they made him go. They handed me his watch and his suit. They got him. But all right, y'all, you guys have a great day. And we'll probably be back. We'll probably be back over here so that we can make sure we keep you updated. Until then, though, I got to get some work done. You guys, like, I rearranged my whole day. So now I got to get a little bit of work done until we find out what happens with Diddy. Until then, I'll holler at you guys next time.